in the night, all our offenses within 5 years. She's not granted bail. She's in the jail. They're not permitting her to go to the hospital. And
she's a lawyer.
She's a lawyer and a serving officer's fiance. And they also arrested and
you have moved the application for bail.
Yes, and that has been rejected. I filed for quashing as well as an application, my lord, that she must
release the bail tomorrow.
No, man, I need it in the after lunch, my lord. She needs to go to the hospital. They're not sending her to the hospital. I want, my lord, AIMS to examine him. This is a seriousness of the matter, my lord. My lord may take it up. My lord will see how serious the matter is, my lord. The entire armed forces are.
Keep it 2 o'clock.
This matter actually, my lord, assigned to another bench. That bench not functioning for that.
Yes, yes.
Just check him up. That my lord.
It would be better if you listed tomorrow.
My lord, the difficulty is this, my lord. She is saying that I am having pain, my lord, and she is not. The doctor in the jail says that he should be sent to the hospital.
I will examine at 2 o'clock. If something serious, then I'll pass the order. Otherwise, tomorrow. Yes. Let it be listed at 2 o'clock.
Yes.
Let us understand what exactly.
Yes.
Yes.
I have filed an bail application as well as a quashing.
Only bail application you list. Only bail application I am listing.
All right.
But I may pardon to mention, my lord.
Yes.
The petitioner is a lady. All the materials have turned hostile. My lord may recollect. On that day, I pray tomorrow.
Huh?
Tomorrow, my lord has directed the.
What is that? Bail?
Bail, my lord.
Bail matter, I will not entertain. This is a very urgent matter. He is a lawyer.
And tomorrow, take as your lordship. I am giving them as your lordship. I leave it to my lord.
Give the memo.
Yeah.
This week will be completing. All the bail you are completing this.
No, my lord. This is fresh bail application. It was
start entertaining fresh bail application. There is no end to it. Every matter has some.
I am explaining. My lord has told that I will grant you bail. That lady has subsequently told since I am directly trial court.
You gave it healthy. Mentioning, I don't want to waste much time in bail matter. No mentioning.
My lord, one interim bail, my lord. What has happened? The petitioner's father had died on 15, my lord. He's the
this bench matter.
Lordship,
you mentioned there. I can't.
No. Functioning.
That bench has given interim order. I will extend it.
No. That doesn't happen. He was not on interim bail, my lord. His father has died on 15th.
Tomorrow in that court.
Pardon to mention, Lordship. Lordship, bail order was passed on 12th of September. Well, my lords, inadvertently the lower court name has been wrongly typed, my lord. GMFC 5 has been typed instead.
My lord, my application may be listed for tomorrow, my lord.
Tomorrow before consent bench. Consent bench.
My lord.
Not before this bench. If I can't take up those matters.
My lord.
Unless it is very, very extreme urgent, something.
Father died on 15 months.
Yes.
Item mention item 154 in the list.
We detect because the FIR they not put on the.
Lordship, item 80 today's list, Lordship. The bail matter. The senior counsel denied was arguing last occasion. Lordship, kindly put up to next week Monday.
Next week, urgent. You are asking adjournment, it will go to its own this thing.
Lordship, kindly
Slot.
Item,
on request adjournment.
well, item 56, my lord.
Yes.
I pray for adjournment.
Adjournment.
Hello.
My memo, my lord, for withdrawal.
Withdraw.
56.
Which item?
I not my lord, out of list.
Tomorrow.
Well, item 113, my lord, permitted to withdraw.
Permit 113 withdraw.
Already acquitted.
Item 154, my lord.
Withdraw. 190? 119. 119. Withdraw. Yes.
Item number 53.
Huh?
Praying for adjournment. Item number 53.
Bail.
Lord,
Interim order is there.
No. CRNC matter.
Interim order is not there.
No.
Urgent to December.
My lord, one criminal miscase, my lord, may be listed. We went to mediation and that is successful. And similar matter also have been disposed of.
Successful.
Yes, my lord. This matter may be listed.
Item 55, my lord.
Settle. Matter settle. Matter settle.
My lord.
Item 55. Pray for adjournment.
Bail matter.
No. Shall
Interim order is not there.
Yes. Item number 154, my lord. Lordship had directed matter to be listed today. whenever lordship finds time to take up, it's a vigilance matter, then we had made a
Let us
submission.
see,
No, he's there. He only asked for the only one matter to be taken up. We have agreed for the one. There are 3 matters. Yes, ma'am. My lord.
Okay.
And I may pardon.
Huh.
On behalf of the bar, we request my lord, in bail matters, the subject of verification antecedent, सेटा न करी cash फैस किसी कले कौन लोगों ने बाहरी
No, no. Bar will not decide what order.
नहीं, we request. So we request.
Bar should have its own limitation. I have my own limitation.
Then
I'll stop giving bail.
नहीं, खाली request. We leave it to.
I rejected it. Go where.
नहीं, bail आगे हजूर मार पछड़ नहीं. We leave it to. खाली request कर.
Case to case basis you can request, but not a general order.
नहीं, general no, जो उठे देखिगी.
See, case to case basis.
I don't associate myself with Mr. Panda's request, my lords. Bail is never Hajur Mahabak, my lords. I have never thought of it as that way. And I don't associate myself with Mr. Panda's sentiments.
Sorry. I didn't follow what you are saying.
Bail is not Hajur Mahabak, as my learned friend said. So I don't associate myself with that part of my learned friend's sentiments. And
He says that some condition, general condition to be imposed.
That should not be made a mention of before the court.
See, that the trial court does it, in fact.
Yes.
Yes, you wanted to mention something, 24 items.
My learned friend was present physically, who is present as made. Amit, Mr. Patnaik has made.
We have worked together now. I don't want to he said 2 p.m. ki 2:30 जो time कहियो से time.
It was for you for.
आगे.
Yes. 46.
May please, your lordship.
Yes.
Item 46, your lordship. The other 2 accused is there, your lordship. May I pray, your lordship. Today I am filing the one of the IA for made the party for petition.
What do you want?
So your lordship, they are filed the case matter for compromising case matter.
Settlement.
Yes.
Installmentally people are coming.
Other 2 accused I say petitioners.
You do whatever, you don't waste time.
No.
See, so many hearings, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 hearings.
Proper affidavit not filed for that is
And the courts are not free, no? Every time you installmentally you come, I'll reject it then.
No, you also kindly consider.
File a fresh one.
You also kindly consider. Your lordship.
What I'll consider, you are settled the dispute, the accused has to be here. What's that to consider?
Because of the other accused person.
Whatever you do. December, urgent to December.
No, lordship, kindly consider.
People are unnecessary taking indulgence of this court.
I pardon your lordship. Your lordship, kindly consider.
First of all, you say settlement. Thereafter, you don't bring the accused persons.
You
file a separate for them, separate petition for them. Why should I wait for them? Are they VIP?
No, your lordship. Otherwise, your lordship kindly permit to me taken up this matter on 9th. I will do.
No, you will not decide the date.
No,
our entire system is getting collapsed because of you.
I pray before your lordship.
No, pray. You tell me. I'll just dismiss it. File a better petition. Let counsel for the petition to withdraw the petition to file a better petition with all relevant particulars and documents. With this liberty, the petition is dismissed. Yes,
in the meantime, may I pray one thing, your lordship?
You file it fresh one.
Yes, I will file, your lordship. In the meantime, they will be protected, your lordship.
I am dismissing the matter.
No, simply, your
lordship. Don't cross some limit, you have to. This is High Court. Responsible prayer you should make.
Simply,
first of all, you file a defective petition. I gave indulgence. 11 hearing I have given you. Today you are asking for amendment. I am dismissing it. Thereafter, you ask me.
Your lordship, kindly consider, your lordship, because
why should I consider, you tell me? Don't waste my time in the morning.
Your lordship, simply withdraw and liberty to file.
Yes, that's what I'm doing.
Hello.
You file a fresh one with all particulars.
Yes.
File tomorrow. It will come.
Yes.
Day after.
Yes.
With all particulars. Thereafter, you don't file 11 hearings you have wasted.
No, I understand, your lordship. I pardon.
Yes.
Hello. Seeking my question of cognizance on the ground of compromise. The family dispute and the
yes. Are they here?
Yes, my lord.
I am appealing for this. What is the FIR?
If that the accuser, the father-in-law and brother-in-law. In front is the
charge sheet has been filed.
Daughter-in-law. Yes, affidavit is there, my lord.
The charge sheet filed.
Yes, my lord.
What are the offense? Because 376 and all.
My lord. That is annexed 2, my lord. Cognizance order is there.
Huh?
That is 15 annexed 2, my lord. 498A, 376.
Yes.
496.
376, everything.
What happened, my lord? The daughter-in-law, father-in-law, mother-in-law, and sister, brother-in-law. Husband not the acting, my lord.
Husband ଅଛି.
Here, my lord, husband name is not there.
Nahi.
What happened in this case, my lord? They stated that their matter has been completed and the informant filed the affidavit, my lord, on dated, my lord, 29 August 2024, stating that the matter
Has been settled.
dispute has been settled due to intervention of judges. Now I am living peacefully in my maternal home with my family. That is my lord.
His where is that? Call.
The subject accusation now.
Ask her.
Subject accusation.
Husband.
How many accused are there?
3 accused persons, but husband not there, my lord, because he is not available. Outside the petitioner.
You have filed the petition for 2.
2 persons. 2 are present, my lord.
And you have not implemented the informant also.
Husband is accused.
Where is the informant?
No, my lord, he is not. He is not influenced, but subsequently filed the affidavit to the informant.
Only they have filed affidavit.
Because in earlier cases,
Do you know little procedure?
my lord,
You have not made the informant party. You filing affidavit. On that basis I'll pass it. Tomorrow somebody take the name of party. It was not a party. What will happen? What will happen? These are minimum things. I need not educate you. The informant has to be a opposite party. And tomorrow some other lady will come that I was not a party. Somebody else appeared. What to do? What to do? Implead here.
today, my lord.
Today, counsel for the petitioner.
Today, in course, Sunday.
And who will file wakalatnama for her? Have you filed wakalatnama?
Yes,
ma'am.
If you are not a party, how can you file wakalatnama? For whom you are filing wakalatnama? Which party? She is not a party. See, all these things are managed. Why are you doing? Don't reduce the High Court to this level. File proper, implead properly. And learned counsel for the petitioner seeks to implead the informant in the opposite party number 2. During the course of the day, you may do so from the time issue notice to opposite party. After notice is issued, then only you can file wakalatnama for a party. Okay. Implead, and he will implead it. Literally tomorrow. Tomorrow.
They're after tomorrow.
Yes, of course. Of course. Next.
48.
Certificate copy 46 से वापस कर दो. Replacing the yes.
48.
48. Yes. Yes, sir.
Before going to the case on merit, I am suggesting one thing. This is a case where offence is alleged on section 420-406 of the Indian Penal Code. It is a case of the prosecution is that the informant is a manager of a private financial institution, and the present petitioner was working as a field officer. It is alleged that he collected money from the depositors who also collected the loan which was in disbursed to some of the loanees, and he did not deposit. I have examined the entire case. I am suggesting my friend to call for the case diary and examine. Not a loanee or the person who deposited the money was examined during course of investigation, nor any document was collected showing that the money was entrusted to me and I did not deposit. That is the crux of the matter.
There may be some 161 statement, though might have said, witness might have said that this gentleman has collected money.
Not a single witness has been examined.
You get the case.
And that's why I suggested.
If my senior malad made the informant of the party, so that it would still go.
Okay.
Implead the informant and issue notice. Okay. Yes.
49.
Implead the opposite party number 2. Informant will be implemented during the course of the day. Issue notice. Call for case check, please.
In course of the day.
Yes. Next. Yes.
49.
49.
Private. Private petitioner. State not.
Password.
50.
50.
My lord.
Press matter.
Press matter. My lord. Quashing of criminal proceeding.
It is pending since
498 to 94.
498.
My lord.
Okay. 498, है ना?
My lord.
Issue notice to opposite party number
2.
2. Returnable after 2 weeks.
51.
Yes. 51. 51 is also like that.
My lord. And same case. No, not same case. Same counsel, my lord. Another case, my lord.
498.
Here, my lord. 498.
Same, huh?
2 cases, my lord. Actually, what happened? The in front of file another one case. Subsequently, another case filed.
Matrimonially.
Matrimonially.
Oh, issue notice. Huh? Yes.
52.
Issue notice. Yes, sir.
This matter and file a press, leave it to file a press bed.
You want to file a press one. Then counsel for the petition seeks to withdraw this petition to file a press petition with the material particulars and instant documents. In this liberty petition is yes.
54. 54, my lord.
Yes.
Leave to just I'll my lord, sorry, my lord.
Yes.
Here, my lord, challenging the order of annexure, my lord. That is
Annexure
5,
3.
my lord. That is annexure 5, my lord. 205 petition has been rejected.
Annexure 3 you are. 53, na?
My lord. No, impugned order is challenging conclusion order, that is page number 13. That is annexure 5, my lord.
54, huh?
Cognizance, taking order the cognizance, my lord.
What is the party name?
Again?
Party name? Acha. Party name.
Akkulo Venkateswaralo.
You have filed 3 annexures only. You are referring to annexure 5.
My lord, 3 annexures.
54.
You are referring to annexure 5.
I am CRNC 48, my lord. Case number.
I don't know. This is 48. It's all right. But
My
you
lord,
filed only 3 annexures.
My lord, lordship correct. 3 annexures.
Why are you referring to 5 then? Where from I
My lord, my more take bhule.
I don't know what.
My lord, sorry. Sorry. मुझे आइली तो अर्थ नहीं जस्ट गोटे पासवर्ड कर दुना मिलट मिलट देखि दो지 फाइल
No, you tell me. I got. This is annexure 3.
आज्ञा मिलट oblige annexure 3 मिलट order of a cognizance मिलट challenge before lordship 138 case मिलट.
Yes, you are accused.
I am my lord the accused मिलट. Here this case मिलट last occasion argue before lordship that is now my lord the petitioner staying मिलट Andhra Pradesh and my lord court मिलट. And that is Rayagada court, my lord. That is the case, my lord. Rayagada court is cognizance taken, my lord. Now the VC system is available. Your lordship, my lord, said VC on VC, my lord, petition may permitted to appear before the court on VC, my lord. Distance in my lord, Rayagada court, cognizance taken, my lord. ADJ Rayagada, petitioner staying at Andhra Pradesh, my lord.
That's right. You are challenging the cognizance order. Have you applied for the this thing? Whatever you are asking, trial court.
What do they, my lord?
You are challenging cognizance order. You are asking saying something else.
139 act of
it.
See, page 14 is your impugn order.
My lord, that
only cognizance under 138 is taken. You are accused.
My lord. Only got a minute. So permission one passover.
You file the petition. You also you don't know what 3. It is only 14-page petition.
My lord.
Whatever prayer you are making, I am allowing it. You go and move application before trial court and trial court will decide it. That's the law.
My lord.
Although I challenge the order dated 29/4/2022, whereby the trial court has taken cognizance of offence under section 138 NI Act against the petitioner. However, the petitioner submits that since the accused is both the accused persons are resident of Andhra Pradesh, so they cannot frequently appear before the trial court. Therefore, they should be allowed to appear and contest the case through video conferencing mode.
Okay.
Video conferencing mode. The petitioner, since the petitioner has not approached the trial court in this regard, liberty is granted to the petitioner to move appropriate application in this regard. If such applications are moved, the same shall be considered. With this liberty, the petitioner is disposed. Next. Yes.
57.
50?
55, 56.
55, 56?
Already, already.
Okay. 57.
57, your lordship may kindly have a glance. To the
My-
document page 15.
15, 1, 5?
One part.
My lord.
Fifth order. Your lordship may kindly have a glance.
Yes, I'm there.
My lord,
Your
on
lordship got 15 page.
Yes,
I am
I'm there.
satisfying your lordship will be at liberty to dispose of the matter at the hearing.
my
The
lord,
hearing.
my lord, on behalf of dear Mahapatra, kindly pass over it.
Only I am referring to your lordship will
Yes,
be
yes,
had both sides,
yes.
peruse the case record and all the connecting documents. Upon perusal of the same, it is seen that the complaint has been examined, cross-examined and discharged. During such cross-examination, the accused has not disputed his signature on the check. Moreover, at the time of recording of accused statement under section 313 CRBC, the accused has admitted that he had signed the check. The record is currently posted for evidence from the side of the accused.
What is the
They are asking, your lordship may kindly have a glance to page 27.
No, what do they ask?
To age of the signature, your lordship may kindly have a glance to page 24.
24.
Prayer portion.
After having admitted,
Therefore, it is declared that the court may be pleased to send the check, etc., to know the about call for a report for
handwriting expert.
about age of that. Age cannot be decided by the handwriting expert. So on this score, on this score, I
understand.
rely on this one. Your lordship may dispose of and target the matter because since January it is.
No, I'll do that. Let him come. Yes.
Oh, let the 8.
There
is nothing in. Yes.
On last occasion, you received direction given to State Council to take the instruction regarding.
The investigation is continuing, my lord. In fact, my lord.
Yes. What is the stage of investigation?
My investigation is continuing, my lord. The accused, my lord, in this case, my lord, he is also involved. IO telephonically, my lord, talked with the IO, my lord. He stated that the accused also involved in other 2 cases, similar cases, my lord, and the investigation is going on, my lord.
No, going on. That see, when it is the FIR up to 3/12/2022. He is in custody in other cases.
While in custody, arrested in this case, and he is subsequently released on bail, my lord. And in fact, my
What
lord,
do you want now? Investigation is
going on, my lord.
22 matter only. And you are involved in 2-3 cases.
Till now, he has not submitted final form or charge sheet.
No, I can't give a direction whether final form to be filed or not. Investigation is going on. No court can give direction to the police. You withdraw it at the appropriate stage, file it. Counsel seeks to withdraw the petition to revise his prayer at appropriate stage if the cause of action still survives. With this plea.
After investigation.
Yeah, I have given it. Yes. Yes.
59.
Made to your lords.
Yes, sir.
Petitioner is involved in a offense under NDPS Act. He is in custody since 6/10/21.
Yes.
Charge sheet was submitted on 26/10/22. It is reported that 206 kg of ganja was seized from him. He has no antecedent. And trial is yet to go.
Trial is going on.
Going on.
How many witnesses have been examined right now?
That I don't know. A status report had been called for. May kindly see.
You are from West Bengal.
West Bengal.
This court is called for status report.
Call for status report. That is there at Black Q, I think.
Black Q.
See, out of 9 witnesses, 4 witnesses have already been examined, and the matter was listed before 8/8/2024 for further trial, and summons were issued to all the other witnesses.
But they cannot keep me active in
This
prison
is what is
for
the court.
eternity. He may have given,
Huh?
but they cannot keep me in for eternity in custody.
No, not eternity.
21, my lord, your
How
lord.
many accused persons are there?
My lord, so far the co-accused concerned, my lord, his prayer for bail, the bail petition, my lord, urgent to 24/9, my lord. That is BL appeal number 9611/2023. Both the cases will take up
24/9, list along with so and so. By that time, you seek instruction what happened. The court of
9611.
and the additional district, additional session judge from special judge Jaipur has submitted a report dated report dated 30th September.
No, 30th September.
August.
30th August it must.
July. 30th July 2024. Whereby he has informed this court that out of 9 witnesses, 4 witnesses have already been examined, and the matter is slotted for set for recording of evidence on 8/8/2024. Mr. Agarwal and counsel for the state to seek instruction regarding
in the earlier case, my lord, urgent bail matter, my lord, there also status report called for by this court, my lord. Kindly available there.
Seek the instruction regarding the press status. Leave the matter along with the bill number
9611/2023.
9611.
23.
24 to
24 now.
Yes.
इतने दिन में रोक हार सकता है एक शुक्रवार असमें नल तेज ना
Date already fixed. Yes.
May pattern, item 58, your lordship direction given to the investigation completed within a stipulated time, my lord.
And give a direction to the police like this.
Time they will say, all for 40,000 percent.
I'll see how what can I do. Yes, next.
60.
Yes.
20 NDPS
Hmm.
50 kg ganja was near
50
kg. I have
custody since
13/8/2023 13/8/2023
13/12
and having no antecedent, my lord.
Yes, my lord, supplied the copy of charge sheet, but in fact, man, two
the
other
50 kilo.
other two co-accused persons their urgent their applications are urgent to, my lord, 19/9.
19?
19/9. 19 tarikh
19 से लोग
3 taka.
all the 3 will grant bail.
It is-
Only
Ekatra-
tag along with yes. All the matters.
CD is available.
CD, yes. Tag with 9.
More per 9 number.
Give the numbers.
No, more per 9.
6637/24. Another 6751/24.
Yes.
Urgent to 9/19. 19 not there. Okay. 61.
Yes.
My lord, the case is under section 20B2C of the NDPS Act, my lord, and the petitioner is in jail custody since 25th September 2023, and charge sheet submitted 22/3/2024 without chemical examination report, my lord.
What is the recovery?
Item 6162, my lord. CD will come from the Machkund PS, my lord. And there is, my lord, dispute in the police station, my lord. Some police officers, my lord, they have no transfer. In the meantime, I also contacted the IO. IO, my lord, assured me
6162. 6162.
He'll send the, my lord, the case diary today, my lord.
Okay. List it next week.
Next week.
Case diary.
Both the cases, my lord.
Case the Mr. Agarwal has not yet received the case diary. 6 1 week time. Yes.
63.
Oblige, lord.
Yes. 63. What is the offense?
Offense, my lord, 373.
Service.
My lord, service absent.
Service is completed.
My lord.
Service completed.
My lord. Service come.
Pass out. before?
498, 306. That's it sometime.
No. Last two occasions nobody appeared, right?
Madam.
On 5/8/2024 and on 12/8/2024 when the matter was taken up, none appeared for the petition. Even today, none appears for the petitioner, hence this case.
65 is for the.
May I please also? This offense is 304 498 A, my lord. My lord, both the petitioner husband, the accused is the husband, wife is the deceased wife, my lord. They are both tribal. They are laborer working under a contractor, my lord. The evidence says that they are coming, they return to their house, maternal house of the wife, my lord. They Jagar Jatra. They come with drinking, both by handia, and they come to the house and sleep. But the person who is the eyewitness was present in the house, in the room, because this is the house allotted to them to read there. She said that before sleeping they quarrel, and when they quarrel and say the eyewitness protested, she was threatened by the accused, saying, "If you protest, I will kill you."
Next day she was found dead.
She says he left the house. In the after about 12 a.m. she left the house. The eyewitness left the house.
Yes, my lord.
He left the house and go. Thereafter, she come and the next day 8 a.m. they come to show that they are sleeping both in the massage. Both are sleeping. And when they call, nobody will recall, my lord. So that they say that the wife has deceased died with blood injury. This is the heaven. They come to the hospital according to the petitioner.
Well, the eyewitness.
Custody case.
5/3/23.
The eyewitness.
I have given the deposition copy.
Yes.
PW1. PW3.
Is 161 statement, my lord. Though he has elaborately stated seen the assault part, but in fact, I have read out the evidence, my lord.
Yes.
By and Singh, I know the informant Chandan Singh, who is my co-villager, as well as the deceased Sita Singh, but deceased, who is the sister of informant. I also know the accused standing inside the dock, who is the husband of the deceased. The occurrence took place in the year 2023. The deceased died after a Jagar festival. At the relevant time of occurrence, I, along with deceased and the accused husband, were working under the contractor Maheshwara as a daily wager. While working under the contractor Maheshwara, I, along with the deceased, her husband, the accused, were staying in a big hall provided by the contractor. On the date of occurrence, there ensued the quarrel between the accused and the deceased. They fought with each other. When I protested, then the accused husband of the deceased threatened me to assault, saying that I had no right to say anything in dispute between the husband and wife. After quarrel, the accused and deceased slept inside the mosquito net spread inside the big hall. I did not sleep in the hall. Out of here. On the following morning, when I came to the occurrence room, found that the accused and the deceased were sleeping in the mosquito net. I noticed bleeding injury on the face and the head of the deceased.
Except this witness, how many witnesses?
Only 3 witnesses. I have given the deposition copy. One is the contract.
This witness has already been examined.
Yes.
His evidence, madam.
This is evidence.
Evidence is there.
Evidence there, madam. Except the matter here.
What I said, man, that is correct. That they are sleeping.
This is court evidence.
Court
evidence. There is no dispute to that, madam.
How many witnesses remain?
Total 19 witnesses.
This honorable directed me to give the witness eyewitness.
There are evidence against you.
Right. You'll also kind of say other 2 witnesses.
At this stage,
other 2 witnesses also they say that they come with dunking. They handia khai ke asile
right, but see, this witness is already there. Eyewitness is there.
কিন্তু ନଥିଲା ରାତି 12ଟା ପରେ ପଳେଇଗଲା ତାପରେ
you renew
ହାଣ୍ଡିଆ ଖାଇକି ଶୋଇଛନ୍ତି
6 months if the trial is not concluded, renew. 6 months. 6 months if the trial is not concluded, the petitioner is given liberty to renew the bail plea before the trial court. Yes. Next. 66.
On bail, Mr. Issa Das, kindly one captor. Bless my lord.
Permitted to withdraw, my lord. Permitted to withdraw, my lord.
68. Yes, madam.
The petitioner is in custody since 8/2/2024, your lordships.
8/2/24.
Lordships.
Yes.
And the alleged offence is under section 419, 420 and 66D of the IT Act. The allegation is like this, that the present petitioner called up the informant, and the display picture of the display picture shown on the record or the WhatsApp was of a police officer. Believing that he is in trouble, he transferred rupees 1,34,000 to the alleged account. Later on, he came to know that it was a fraudulent transaction, and then it has opened the Pandora's box. During investigation, it is found that
what was found in that box?
7,38,000
Only.
So
far.
No, your lordship. It is investigation is completed. Charge sheet has been filed.
Preliminary charge sheet submitted.
Like,
1,34,000 was transferred to the petitioner account, and that mobile number stands in the name of the petitioner. Because
he has done with one person, it's all right. How many persons he has treated like this?
there is no the investigation.
Isolated incident.
No, there are, to be fair, they are series of transactions. From last 2 years, they have found there are about 12 number of, and total amount comes to 7,34,000. Odd one.
And my lord, preliminary charge sheet was submitted. Preliminary charge sheet was submitted on 5/6/24.
5/6?
5/6/24.
It says charge sheet, doesn't say preliminary charge.
And rejection order was
5/6/24.
5/6/24. And rejection order is 19/2/24.
But
and the petitioner has 12 numbers of State Bank account is also seized.
Accounts, having accounts will not.
Account, but you.
No, he has cheated. This.
I'm not denying that fact.
And no.
1 lakh.
See, the problem is, had it been a one issue, then one can
Yes, sir.
understand.
That to be fair, I'll submitted.
Since the charge sheet is filed subsequently, you renew your bail.
I suggest that my humble contention is 1,34,000 is due. Let me deposit some amount and go. I am willing to deposit.
But no,
deposit.
Other people are also there.
Other people, they have not referred an FIR, lodged an FIR as yet. So there is no, if that was
other persons have not come forward.
They have not
Other persons have not come forward.
So
and in the investigation also, there is involvement whether he has cheated to any other person or that is also not there.
So,
no.
that part is not
Let
there.
he deposits that amount, my lord, subject to
deposit
without any prejudice. He has to deposit.
This is not a court direction. This is you who is volunteering. I'm not.
It's on record. You'll actually find it on YouTube also. So that's not an issue. It's my suggestion, my lord.
Petitioner is accused in such a case. Allegation against the petitioner at the outset, calls for the petitioner submits that the dispute is regarding fraud being committed for an amount of rupees
1,34,000.
1,34,000. On instruction, she submits that she would be depositing the same amount. Petitioner is in custody since 8/2/2020. Regarding being held to the period of custody and the volunteer statement made by legal counsel for the petitioner to deposit the amount, disputed amount. The petitioner is enlarged on bail with all conditions, and he should appear before the
with their condition. Yes,
with
such one.
And subject to verification of the similar.
May I pray just 1 lakh instead of 1,34,000 to round it up?
130.
134. It's 1,35,000. 1 lakh.
No, it
may be 1 lakh instead of 1 lakh. So that will be rounded up.
Full amount.
Oh, lordships.
It may be a case of passing also.
It's not.
Never know.
Lordships.
Subject to appearing before the police for 6 months on the Sunday and verification of similar.
Lordships. They may be similar antecedents, your lordships. Your lordship may say in lordships, if I don't know.
Similar, no, there is no. That's what you
that
said.
that is what my state government council also said.
That's what you said.
Lordships.
Similar.
69. Item 69 kindly taken up next week, my lord. 69 kindly taken up next week, my lord.
Not next week.
My lord, a letter was come from the ad hoc additional session judge. That is flag P, my lord.
Flag E.
Flag P.
Like E.
P, my lord.
P.
My lord.
Okay. What is the offense?
My offense is
376.
376 2N, 366, 365, 6 and 17 POCSO.
Oh, he's asking for adjournment lady.
My lord.
Because the charge has been framed, summons were issued to the victim, and she has not appeared. That's what.
And out of 23 witnesses, 15 witnesses.
Request adjourned. Yes.
My lord. My lord.
Adjourned as per your request. Yes.
Petitioner is in custody, my lord, since 3/2/24.
3/2/24.
24.
Okay.
Alleged offense, my lord, 326A 506/34 of the IPC. Injured discharge from hospital. Last occasion, no lord.
326.
Yes, ma'am.
326.
Yes.
The lordship call for a instruction whether
307.
actually he is working as a boardsmith. That the present petitioner. He has thrown some suspected acid, that is sulfuric acid.
Where from he got that?
My lord?
Acid.
Sulfuric acid.
Sulfuric acid.
And he has sustained, the injured has sustained grievous
injury.
One is
Discharge
an
from
eye
hospital.
and arm, leg. Eye is, my lord, grievous. That is.
Goldsmith, huh?
Father-in-law, son-in-law.
Goldsmiths are using that.
Yes,
yes. Petitioner is the father-in-law, son-in-law. Victim is the son-in-law.
He tortured the daughter.
Yes, including left
Yes.
eye. Eye is damaged.
Eye was, my lord, grievous
grievous
injury.
in nature. Last occasion, no lord, he wanted to see. Yes, ma'am. Wanted to see what is the acid.
No, acid, it's all right. Have you implemented the? I just want to see if the eye is.
No, that is grievous in nature. It discharged on 8/2/24. He is the son-in-law. Petitioner is the father-in-law. The daughter was tortured, for which he throwing the acid.
He is the father-in-law.
Father-in-law, man.
Okay.
Shasuro jui.
With condition,
The condition was that injury on the eye.
that is I am worried about.
My lord. Leg and hand, that is different. But there is injury on eye and eye is grievous injury. So
Why don't you implead the informant injured? Implead, let us see. And it may go
your lordship, consider last occasion, your lordship. Last.
See, I was thinking the.
That is the grievous in nature. Yes,
Grievous, I understand, but in the eye, if acid put in the eye.
Your lordship, kindly, this is a certified copy.
I believe you. It is grievous only, but the eyesight might have been affected also.
Ye torture kala boli ragore pokke dela.
Ragore kahe? So, some jagada ragore hui.
Rohilani 7 months, more than 7 months is in custody. Old man.
Eye injury, so eye injury is,
old man is in.
My lord?
Charge sheet submitted, my lord. On 3 charge sheet submitted, my lord.
Charge sheet filed?
Yes,
I have instruction that
I
have instruction that charge sheet was filed.
This, check it up.
Charge sheet with me, my lord.
Day after tomorrow. Keep it. Day after tomorrow. Come with, Charge sheet, Charge sheet to whether 307 included or
not.
No. 1 minute. Ask the IO whether his eyesight is all right.
Right.
Just ask. Okay. Day after tomorrow. Yes.
8 charge sheet certified copy.
Day after tomorrow.
Copy.
Only eyesight, you just tell me. Eyesight is affected or 71?
May I please, your lordship?
Yes, madam.
Your lordship, the petitioner here is the husband who has been charged under section 498A and 302, your lordship, and is in custody since 4/1/2024.
4/1/24.
Yes, your lordship.
What are the allegations?
498
Why 302?
304B, my lord. And marriage was before 5 years, having a child.
Maybe 304B, it's all right, but why 302?
My lord, because that is, it is likely to be poisoning.
that allegation is likely to be poisoning. But viscera report has not come. My lord, I am giving some poison bottle was also seized.
No, that's right. Everything is all right. Whether this man has administered.
My lord, why, my lord? Because
administered the poison.
My lord, because the husband, that's present petitioner, deceased, and child, they were sleeping in the night. Then after in the morning, that the deceased was died. So it is suspecting that he was administered poison because he was not absent at that time in the home. They were sleeping at that time with the child, my lord. And mother, the present petitioner mother statement, I am reading, my lord. मोर रिलीवेंट पर्सन माइ लॉर्ड 5 वर्ष तले 23/6/19 राउतपड़ा मठर थिबा दिवाकर त्रिपाठी झियो शुभस्मिता त्रिपाठींकर बामला स्थित लक्ष्मीनारायण मंदिर रे मो पुओ मानस रंजन पंडा प्रेजेंट पिटिशनर सहित हिंदू रीति रे विवाह होइतिला विवाह तार बापा दिवाकर त्रिपाठी आसी नथिले उक्त विवाह स्थानीय ब्राह्मण समाजर सहायता रे झियर मां भाग्यवती त्रिपाठी सोआनसो एवं तांको पुओ औरसरु गोटे पुओ जन्म होइतिला जहार ना साई पंडा तार बयस 4 वर्ष मोर पुओ बालेश्वर इलेक्ट्रिक शोरूम रे सेल्समैन भाव में कार्य करुला स्वामी स्त्री मध्य अनेक समय पाटितुंड लगुले एपरिक मानस तार स्त्री को गालीगुलज करने सहित पिटामर करुला पुओ को जिते बुझाइला से मोर कथा को शुणु नथिला यह केन्द्र करी बोहू मरिबार 8-10 दिन आगु तार बापघर केन्द्रापड़ा पळाई जाइतिला बोहूर बापघर लोक मैंने बुझाबुझी कर आम घरे छाड़ी जाइतिले पुओ बोहू काम करथुवा दुकान मालिक को तार दरमा पैसा पुओ को न दे तार अकाउंट रे पठाइबार मु सुनिछि 22/11 तारी राति रे पुओ बालेश्वर काम सारी आसी पुओ बोहू सांगरे पाटितुंड करथुला से दिन राति रे पुओ बोहू खाई सारी गोटे रूम रे सोइथिले तापर दिन सकाळ देखला बेलकु बोहू मरिकी पडिछि दैट इज द स्टेटमेंट ऑफ द पिटिशनर्स मदर राइट
Viscera report is still awaiting.
Viscera report is awaiting. And poison, that bottle was found. And though they were in the room in the night.
At least after 2 weeks, awaiting the viscera report. Waiting. Yes.
72. My lord, that order may be free copy given. That free copy of the order may be given. I will communicate to the SFS.
Viscera report. Awaiting viscera report. Please, the Mr. Mishra, let us also for the state to submit that in the present case, viscera report is still awaited. Will be matter after 2 weeks.
72. May I plead your lordship? The petitioner before your lordship is in custody since 8/8/2023. 2023.
Okay.
For commission of offence under section 363, 376(2) and 376(3) IPC, read with 6 of POCSO.
Yes.
First of all, I invite my lord's kind attention.
164 read.
Yes, your lordship. That is at
page 75. Meantime, he has filed some deposition copy. 72.
No, 72.
He is 28 years old.
Lordship.
164 read. What
Now,
is the age?
page 75, your lordship. 16.
My age is 15 years, 4 months, 14 days on the date of occurrence.
Your lordship, page 75
Petitioner
is
is married man.
no,
No. Petitioner is not a married.
Your lordship, page 75 is the 164 statement.
Read it.
Lordship. ମୁଁ ଆଜି ଏଠାରେ ଉପସ୍ଥିତ ହୋଇ ଶପଥ ନେବା ପୂର୍ବକ ଏହି ସତ୍ୟ ବୟାନ ଦେଉଛି କି ମୁଁ 4/8/23 ସକାଳ 9ଟାରେ କଲେଜ ଯାଇଥିଲି ସେଦିନ ମୁଁ ଯାହାକୁ ଭଲ ପାଏ ହେମନ୍ତ ପଣ୍ଡା ମତେ ମୋ ଇଚ୍ଛା ନଥିଲେ ମଧ୍ୟ ରାଉରକେଲାକୁ ନେଇକି ଯାଇଥିଲା ସେଠି ସେ ମତେ ସ୍ୱସ୍ତିକ ଲଜରେ ରଖିଲା ସେଠି 2 ଦିନ ରହିଲୁ 4/8/23 ଓ 5/8/23 ରହିଲୁ 5/8/23 ରାତି 3ଟାରେ ଆମେ ଟ୍ରେନରେ ବସି ସମ୍ବଲପୁର ଆସିଲୁ ସମ୍ବଲପୁର ରେଲୱେ ଷ୍ଟେସନରେ 6/8 ଓ 7/8 ରହିଲୁ से हेमंत पढ़ मत राउरकेला जीवा आगु मो सह जबरदस्त शारीरिक संपर्क रखी थिला
The present case notice has been served to the victim on
14/9/24.
14/9/24. Hence he submits that let the matter be listed after 1 week. List the matter on 1 week.
The lordship it will be listed
1 week will give it.
73.
POCSO.
See deposition copy would have my lord. Let us solve the deposition copy.
Deposition copy, give it. You have? Do you have?
Well, a deposition copy they have filed before the court. So a copy may be given. This is the noting that they have filed deposition copies.
And let us. Yes.
It Arjun pass over my
POCSO.
74.
74. Yes. What is the offense?
3762 and 470.
Nobody there. So pass it.
75.
75, may I please, my lord?
Yes.
My lord, I'm incarcerating since 25/9/2023.
25/9/2023.
9/2023.
Okay.
My lord, allegation under section 302. And my lord, so far as my name is concerned, the present petitioner is concerned, my lord, I'm Subhas Naik.
Yes.
And my lord, on the last occasion, your lordship has partly heard this matter. And
No, I don't remember you.
my lord, there are two eyewitnesses in this case, my lord.
Yes.
One is Radha Naik.
What is the outtake
My
attributed
lord.
to this man?
My lord, in the connected matter, my lord, this honorable court has directed to examine the eyewitness Radha Naik. That is in
That has been
number
examined, my lord.
3383 of 24.
That has been examined, my lord.
Examined.
Yes, my lord. Radha Naik
And
has
apart from that, my lord, another two eyewitnesses are there. Sukanta Naik and
Sukanta
Raja
Naik.
Naik.
Raja Naik is not the eyewitness, my lord. So Sukanta Naik is the
Raja eyewitness.
and they have been examined.
Out of three eyewitnesses, one eyewitness.
No, my lord. No, my lord.
All the three.
Even if the informant has been examined. I may submit the copy of the informant.
Give it to him.
I'm giving a copy, my lord.
Give it. Please sit after let the counsel for the petitioner submit that all the eyewitnesses in the present case has already been examined. He wants to place on record the
Certified copy, my lord.
eyewitnesses. Let him file the same, least after 1 week. Give a copy. Advance copy to the
Already given, my lord. That may be recorded.
advance copy is supplied in the court today. Prepare it.
My lord.
If no, nothing is there.
No, eyewitness, only the deposition copy I will verify whether.
Verified.
Because, my lord, eyewitnesses have not stated anything.
1 week after. He's entitled to read. Yes.
76.
Grateful, my lord.
Yes. 76.
Minutes, item 76, I pray for on POCSO minutes.
POCSO?
Yes, ma'am.
Yes.
77.
May I please?
Yes.
Initially, the case was registered for the offense under section 363 IPC.
Yes.
Subsequently turned to 372A and also other offenses.
336 2A.
363, 366, 323, 376 2A, 373, 642 and 109. I have
this order.
The surrender certificate.
Surrender courses they have given me. Surrender certificate. In right time, he has surrender.
No, what are you giving this? What is this?
My lord, I am clarifying, my lord.
Hey, what is this, by the way?
My lord, the surrender certificate. Yes, surrendered in time.
Okay, surrender certificate.
Okay. His brother expired. That's why he has gone to attend the
Come to the merit.
My lord, merit I have annexed page 28. There is no allegation of rape against me. Only I have helped my brother-in-law. So that's why 109 is there.
366 and 363, 109. Charge sheet was submitted against the petitioner. But this honorable court has issued notice to the opposite party number 2 because 376.
What is the service position?
And the offense was 373, so honorable court has
Service
issued
position,
notice.
service
But here notice is not required.
Service position is
Notice could not be issued due to non-filing of cost of living. Notice could not be issued due to non-filing of cost of living.
Filed.
not done.
Why the notice not required because
Not required, but there is an order of the
there is,
coordinate bench. I can't ignore that.
that is true.
There is a clear order. You know, that day you should have told the court. Once the coordinate bench asks to issue notice, serve the opposite party or to serve. Notice on opposite party number 2 could not be served. Have you implemented opposite party number 2?
Not implemented.
See the order.
Not implemented. Notice commit what we tell.
See the order. You should have implemented.
I will file press contact
Let the counsel for the petitioner seeks to comply the order dated 14/4/2024 passed by the coordinate bench. Adjourn the matter up to CS. Next.
And I mean, pardon, surrender certificate.
Surrender certificate.
Which have come record.
He further you have to file it. He further submits that pursuant to the interim order, he was released and thereafter he submitted. He surrendered before the jail authority and wants to file the surrender certificate. He may file the same during the course of the year.
Okay. 78.
Yeah, petitioner languishing in the jail for 6/2/2024.
6/2/2024,
my lord.
Yes.
Offences are, my lord, 341, 354, 506.
Sorry?
341, 354, 506.
Yes.
354 by 34 by 8.
My lord, last order, your lordship has passed this order against the co-accused person.
No, co-accused is submit. Your lordship kindly see. So the FIR was registered. My lord, occurrence took place on 24/1/2024. FIR was registered on 3/2/2024. After 2 days. The allegation is that while the daughter
He is a blind girl.
My lord, what he has never stated, they have outraged my modesty, and also.
But she is a blind.
Man, that is gave a slap. Your lordship can 164 kindly see.
Blind girl, minor blind girl.
Blind girl has stated they have never crossed any part of the body and also only gave a slap.
But I have passed.
And my lord, rejection order also stated. Your lordship may see the rejection order. Whether they have touched or not, that will be decided at the time of trial.
And also refused for medical examination. And never touched. From custody from 3/2/2024. So if there is no allegation of sexual assault and gave a slap and custody from that.
See,
and
164 statement up to the blind girl who is 16 years reading.
And yes, man, I'm giving my lord what he has stated, my lord.
But I have taken a view in so far as the co-accused is concerned.
He has not placed, my lord, that he has not placed.
Maybe I can't differ it.
So my respectful submission, my lord,
exploitation by a blind girl.
No, he has only gave a slap.
Whatever.
And he had
you are 28-year-old man.
Only
and this girl is 16. She's a blind girl.
Blind girl is correct, man.
And you,
but he has
3 people grouped her and started harassing her.
Never tossed, my lord.
Anyway, I have taken a view. What can I do?
My respectful sovereign.
I can't take a different view.
I was before charge sheet, my lord. I will renew my term before after charge sheet. And you can also.
Let counsel for the petitioner submits that the counsel. The petition is agreed by the order dated 20th March 2024, whereby his bail plea has been rejected. Subsequent thereto, charge sheet has been filed. On?
A charge sheet was filed on, my lord, 20. Just 1 minute. That is on 22nd 3/2024.
22/3/2024. In the changing circumstances, you want to renew his bail plea before the court of arbitration. With this liberty, the petition is taken. I'll not say anything regarding.
Yes, my lord.
Yes.
79. May please lodge.
Yes.
May please lodge, my lord.
Yes.
My lord, petition is in custody, my lord. 9/2/2024, my lord.
9/2/24.
My lord.
Yes.
The offense under section 21B of NDPS Act, my lord.
Sorry?
21B of NDPS Act.
Recovery?
76 gram.
76
gram, my lord.
76.
And he has also similar nature of antecedent.
What to do? Similar antecedents? Brown sugar?
My lord. Heroin, my lord.
I'll pass the same out. Verification, subject to verification of similarly allowed. Huh?
Last question, CD. Similar, my lord, one similar antecedent there, my lord.
I'm not saying anything. You do whatever. 9/2/2024. Okay. You have done your job. Yes.
80 charge on it.
81.
May I please? My lord, 493, 417, 294, 506.
Custody?
My lord, he is inside custody from 13/3/2024.
And here your lordship may grant him bail. Because the victim lady is 45 years, having 5 children. With the pretext of marriage, the petitioner has kept relationship.
Okay. 376.
Subsequently, charge sheet filed under section 376.
376.
Initially, it was 493, 417. Subsequently, 376(2) charge sheet was filed.
Okay.
164 ରେ ସେ କହୁଛି ଯେ ଆମେ ଦି ଜଣଙ୍କୁ ପରସ୍ପରକୁ ଭଲ ପାଉଥିଲୁ।
Petitioner is accused in charge sheet in the after investigation. Charge sheet has been filed on 5/4/2024 for alleged offence under section 493, 417, 294, 506, and 376 2N of IPC. The victim is 45 years.
Having five children.
Five children. The present petitioner is 40 years, 40-year-old. The petitioner is in custody since 13/3/2020. I fill the statement of the victim under section 164. 164 CRPC. Having regard being head to the nature of allegation and period of custody.
Obvious.
82.
Already 82, 200 kg ganja, 20 feet 2IC. The co-accused person 1, Pintu Pradhan, that is BLAPL number 4748 of 22.
He was granted the interim bail.
Interim bail, surrender certificate is not filed. Well, co-accused persons for the same thing, though surrender certificate was not there, he was not surrendered, lordship dismissed, and you directed the court below to issue.
He has also, I think, not surrendered. That is why they take interim bail. Pass over. Surrender certificate. I dismiss it. It's surrender certificate.
83, my lord, 302. CD, my lord, CD required.
All for CD. Yes.
84.
84.
Yes. 85.
May I please?
Yes.
Petitioner is in custody since January of this year, my lord, for commission of offence under section 302. FIR allegation is there. The petitioner is the owner of de-addiction center.
Owner of?
De-addiction center.
Drug rehabilitation center.
And the brother of the informant admitted there on 4th of January 2024. And he died on 22nd of January due to some other reason.
Okay. What is the report?
My lord, that the charge sheet was submitted under section 302/34 IPC.
Yes.
The PM report is that, my lord, due to myocardial infarction.
Yes.
It is means that is heart attack. But my lord, doctors' opinion, some of the eyewitnesses have stated that they are assaulted, the deceased. The pipe, that the plastic PVC pipe was seized. And my lord, some of the witnesses were 164 statement. They have also stated that they have assaulted. Eyewitnesses are there. But my lord, the team of doctors, those who, though doctor has given that it is a myocardial infarction, a team of doctors, they have opined that. I'm reading that portion, my lord. That after perusal of the documentary evidence for all practical purpose, date of the disease might be due to acute renal failure. Acute renal failure, my lord, that is the kidney failure. As a result of myoglucoburia and arising out of multiple injuries sustained on the body of the deceased. So that is due to multiple injuries.
He was a
That
drug
is
addict or alcoholic. But he was taken to your addiction center. He might have been uncontrolled. People have.
But the cause of death is
black and blue.
Cause of death is cardiac arrest and
let the doctor be examined, my lord, because the doctor has given, let the doctor be examined, because the team of doctors, they are giving different opinion.
Cause of death is not injury inflicted.
Death maybe because he is a weak guy and multiple injury. How
Let it be next week. I will because of other than the FIR and 161 statement, I don't have anything.
The doctor examination you renew, please. 302. This is
Your Lordship may keep it next week or any other day.
Next week we
One
can't
chance
take
may be
it.
given. I have to
Rather
peruse
you-
the CD so that I can defend properly, my lord. Because of other than the FIR and
Then
161
counsel
is
for the
not there.
petitioner seeks to seek an adjournment, please the matter. No more. And
86.
May please, Your Honor. A petitioner returning in jail custody 31st July 2023.
31st July.
Sir. 31st July 2023.
Yes.
And he
Offense.
is a driver.
20B twice, 20B twice is 750 kg was seized from the truck. He's the only person inside the truck and belongs to Madhya Pradesh.
No, sir. Principal accused Yusuf Bhai, Sanjeev Sabar, Bharat, Jalandhar, all are in custody. He is a driver. Sir.
What did he say?
No criminal antecedent.
He's in custody.
No. Chance bail. No chance of bail.
Because there is a time for the final charge sheet.
Final charge sheet
time.
has not been
No,
filed.
final charge sheet was submitted.
Charge sheet is submitted.
Submitted.
When?
Because 1 year he is in custody.
When?
Charge sheet was submitted on
All principal accused in detaining custody.
24/1/24.
24/1/24. Okay. And
He is a driver. Sir, principal accused all are in custody.
no, but
No, who is principal?
regard being had to petition is accused also. Regard and what is the quantity?
750 kg.
750 kg of counter ganja, contraband ganja was seized from the petition. Regard being had to be safe sales. I'm not inclined to enlarge the petition on bail. However, petitioner is given liberty to renew the bail plea after the material witnesses are examined. After the material witnesses are examined, you just see. Yes. I'll just come.
April.
29 April.
24. Two of the petitioners. Two petitioners just standing in the waiting box.
There are two petitioners.
Two petitioners.
Yes. Huh?
CDS.
CD. Call for CD.
They already direction was there
Call
since
for
April.
CD. Without CD, I can't grant bail. CD. Call for CD.
Can
Just
I
after 1 week? Huh? Yes.
next week? May I pray for next week?
Yes. 89 is over, na? 89.
Oh, if I may please, your lordship, my lord, 79 grams of brown sugar in custody since 34/2024.
34/2024.
My lord, he has one criminal antecedent, but that was not from his exclusive possession, and the bail order is
CD is there, CD.
Yes.
Huh?
My lord, may permit me for one moment. My lord, in the previous case, my lord, it was on a basis of a co-accused statement. This is
Whatever I am.
My lord, I'll request your lordship to consider the bar under 37 for a below commercial quantity case may not be taken where it is.
What is the?
My lord, 79 grams brown sugar from my possession.
Subject to verification.
My lord, sir.
Custody since
34
30th April 2024. Subject to verification of bail.
My lord, but kindly have a glance at your last bail order.
I gave the bail.
My lord, but subject to verification, my lord.
Obviously, that I can't. I don't know. By now, there may be another case. Who knows?
My lord, one case I'm submitting, my lord, say
It's all
good
right.
case.
I have given bail. Next.
Obliged.
My lord, if the accident case is in jail custody more than 5 months, my lord. Case was initially registered under section 279, 337, 338, 304A IPC and 185 of MV Act. In the meantime, my lord, charge sheet has been submitted 7/6/24, and the IO written the course of investigation the spot was visited. The PW Soyer examined proved the occurrence well and adduced prosecution liability under section 279, 337, 338, 304 IPC and 184 MV Act. And the doctor opined the cause of death due to the therapy injury and the complication in the PM report of deceased Sujakanta Ghadai, MO Dr.
Your custody since
Custody since my lord 10 for 24, my lord, more than 5 months.
4/24.
24, my lord.
Charge sheet filed.
Charge sheet filed, my lord.
Yes. For which offenses?
279, 337, 338, 304
Yes.
IPC.
What are the allegations against him?
184 MB Act.
Sujit Kumar. Yes, sir. What else?
Actually, recklessly he was moving the vehicle from left side, directly came when all these persons are going in their own way. He came from the left side and dashed to the 3x3 bike, and 2 have been injured, and 1.
All of them are injured only.
Yeah. No, 2 has been died.
2 died.
3 persons were moving in a motorcycle. And the petitioner, the petitioner's car was came and dashed against them. And okay. And out of the 2 died and 1 was injured.
When the charge sheet was filed?
7/6/24, my lord.
7/6/24.
Before rejection.
7/6/24.
After rejection.
And rejection?
Rejection 8/5/24. And charge sheet is 7/6/24.
2 people died, huh? 8/5/24.
184 MB Act, my lord, negligence of driving.
But you have to go, 2 people died. Here, write down. Petition is agreed by the order dated 8/5/2024, whereby his bail plea has been rejected. Subsequently, thereto, on 7/6/2024, charge sheet has been filed in the present case. In the changing circumstances, petitioner should approach the court of first instance by renewing his bail plea. With this liberty, the petitioner is disposed. Next, yes.
91. Make legal similar below commercial quantity. Petitioner is a lady Miller and custody Miller 26 for 2024.
26
for 2024. Below commercial quantity, no criminal and
commercial quantity, what is the quantity?
120 gram Miller.
120 gram.
Yes.
Gram of brown sugar.
Brown sugar.
Lady, 120 gram of brown sugar, which is below commercial quantity. The petitioner is a lady, is in custody since 26/4/2024.
Charge sheet 22/6/24.
Lady.
Rejection is 6/5/20.
Wherever bail is not to be granted, then I am telling you. Wherever bail is to be granted, I am granting you.
It's subject to antecedents.
Those things will be subject.
I mean, excuse my lord, item 90, you will also be remanded to the session judge.
Yes. Thank you.
In this case, my lord, initially FIR lodged under section 498, 304B, 302 by 34 of IPC, and section
302.
Yes, my lord, 4 of DPX. Thereafter, charge.
Your husband.
Yes, my lord. Charge sheet submitted under section 498, 306 by
306.
306.
Custody since?
And custody since my lord 21/4/2024.
What are the allegations?
And charge sheet. Yes, my lord. In page 16, my lord. And the rejection order itself reveals that because of that, the deceased was died due to cerebral anesthesia and its complication thereof as a result of antemortem hanging. Page 16.
No, you show me anything that how the incident had.
Incident, my lord, there was a demand of dowry was
So
there.
those
my lord,
things are,
initially.
on that day, what had happened? You tell me.
On that day, my lord, there was a omnibus allegation against all the family members, my lord. In the charge
What
sheet,
happened on that day? I'm asking.
Yes.
How's he died? Anybody has seen it? What happened?
there was a quarrel between the deceased and the petitioner, my lord.
It is that part. That part of the
prior to that.
Yeah. Evidence. How's he died?
By hanging
By
herself.
hanging herself. Actually,
Oh,
before
what happened on that day?
For that, he was saying that the grinder was not functioning properly. Then when he asked that each and every day you are making the damage to the grinder, why you are not bringing from your father-in-law, father house? And he said that same thing I am not doing, you ask to your mother. After that, the quarrel between them, then he went away for his shop. In the meantime,
Who went away? The
husband.
petitioner went away.
Yes.
He was not there in the house.
At that moment, he was not.
At that moment, I am asking that you read that part. When she committed suicide, that time he was not there in the house.
himself, he has said, and other also have said.
Show me that. I'll pass it over. Just read that part.
No,
huh?
I'm reading that one. आज 2-3-2004 समय मोर दिस संजय कुमार पाढ़ी এই কি যে পাখাপাখি 6টা PM সময় উক্ত ঘটনার স্থলକୁ গলি উক্ত স্থানে গলা বেଳକୁ জামি হারিকে আত্মহত্যা
Head Umakanta Bag was missing since 27/11/2023. After 1 month of the alleged incident of missing, the informant alleged that
When charge sheet was filed?
charge sheet was submitted on my lord 23/4/2024.
23/4. Okay.
My lord. Thereafter, the bail application was rejected.
Okay.
In the
Custody since?
custody since my lord 27/12/2023.
Yes.
After 1 month of the missing of said Umakanta Bag, the co-villager of the informant stated that he has known the occurrence.
Yes, sir. What are the evidence against him?
Admittedly, there was no eyewitness to the occurrence and nothing has been seized from the.
Yes.
Eyewitness is not there, but 116 statements are. I'm reading that one.
Don't read the entire. Read the relevant part.
That's then I'm reading the Lakshman Kalu 42 years. That
What are the evidences against this man? Chandramani, what is it? Chandramani?
actually there will be relation between them, the wife of the deceased, let's say. To kill them, they both have made the plan and they have done this thing. It is the confirmation statement also be there.
And what else? Complainant statement and
169 statements of both of the complainant of the wife of the deceased as well as the petitioner.
petitioner.
Yes.
Read out.
While they were in custody.
Read out. I'm passing it over. Please read it out. I can't.
More good
For small matter, I can't wait for your response. Next item. Pass it over. Next item. Pass over.
Please, your lordship.
Wait. So many matters.
Your lordship.
Admittedly, there is no
Wait.
eyewitness to
Pass it over. Let him go. Yes. Next.
Lordship, the petitioner is inside the custody since 17/4/2024, sir. Alleging of offense under section 409 and 420 IPC, sir.
Yes.
As for the FIR of one Sagar Gowda of CRM Ujjivan Small Finance Bank Limited, Sambalpur, sir. Alleging that, sir, the present petitioner.
Charge sheet filed.
Sir, already, sir, filed.
Yes.
Sir, here the present petitioner is an employee of Ujjivan Finance Bank Limited, and he is interested to process the loan applications, bank accounts, and customer relation, etc., sir.
Yes.
As for the FIR, sir, 5 customers of the bank are complained to the manager that they are misappropriate the cash amounting to 10,000 rupees and most over 21 for 30, sir.
When?
That's it, file, sir.
Give the date.
17/4/24.
17/4/24. Okay.
In this case, my lord, I am appearing for the informant. The petitioner has himself admitted regarding the misappropriation of the amount. I filed an objection. Your lordship may kindly take note of flag C. There is an objection. There is an undertaking by the petitioner admitting regarding this misappropriation, and he himself is assured to repay the amount.
Where
Page
is that?
5. Page 5.
Page 5 of your?
Of my objection, flag C has been.
Flag C.
Flag C. Page 5.
Flag C, yeah? Yes. Read it out.
आज्ञा मु शुभम कुमार नायक मु निम्न कस्टमर मानकर लोन पैसा नहीं छी आ मु ए सब कस्टमर को पैसा मध्य देबी पूरा दिया है डिटेल्स
Yes, you have admitted that you have
Sir,
misappropriated.
but your sir, no was complaint before the police, sir.
In the trial court, you have admitted. Now you are
Nice, sir.
making
No, sir. The document not supplied to me, sir. It is not a part of record.
I have already through WhatsApp to the outer day.
Sir, it is the audit report of the company bank, sir, only.
Filed objection to the bail application. Copy of the same is not.
Because sir is appearing through hybrid mode from Sambalpur. He had
Supplied.
shared the WhatsApp number and shared through WhatsApp, and he has
Supplied.
acknowledged my lords.
Press copy.
My lords,
Copy
I-
of the objection we supplied. Reach up to CS.
Obliged, my lords.
95.
May I please, Your Honor?
Yes, sir.
Offense under section 376(2) 506,
Yes.
section 66A.
Custody?
67. He's in custody since 5. Who देखिए? I may be pardoned for a moment. 5/1/2024, Your Lordship.
Yes.
But the alleged victim and the petitioner are related distantly as brother and sister.
Yes.
He said she developed a love relationship with the petitioner in the year 2022, Your Lordship. A petitioner subsequently got married.
Read 164. What are the?
But evidence copy has been filed, Your Lordship.
Read that part.
The victim has been examined.
What does?
May I just, to Your Lordship's kind permission, place it? I am the informant victim. I know the accused so and so as he is brother-in-law of the sister-in-law of my sister. That is relationship I was saying. The accused side had given proposal for my marriage with the accused in the year 2018. So I developed love with the accused since then. After some days, the accused family denied for the marriage. The accused had captured my nude photos and videos during our sex.
Thereafter, she, on due to disturbance violence, she lost the affair on 23 March 24, and he was arrested on the same day.
376(3) is there.
Yes, my lord. I pray, my lord, one thing, Lordship may allow me 2 months, and I will file as a joint appendix before Lordship, my lord, only my lord. He is very in a precarious condition, my lord.
Notice has been served. Notice has been served.
Only notice issues, my lord.
2 weeks. Let counsel for the.
My lord, already have notice issues.
You get the 376(3) wife and husband, get the affidavit and
No, if Lordship may allow me, I am agreed to accept, my lord, as per the opinion of the statement of the victim, opposite party number 2. For that reason, if you allow me 2 months, then I will accommodate all, then I will submit before Lordship, my lord. For that reason, I
I
am
didn't
saying.
follow.
Total
2 weeks, 2 months means what? Interim bail.
Yes, my lord. Yes.
Interim bail, you will go and persuade the victim.
No, my lord. Choto Chari now is बहुत अबड़ा अवस्था है. So far, tell me.
Argue on merit. If you have a case on merit, I'll grant bail. What is the big deal about it? Wife and husband, 376.
All notice issues, my lord.
He has gone away.
So show me the position of service here. What? Through IO, sir, Friday. Wife and husband, 376. What kind of allegation? There is a child also.
He is agreeing to bring her. That is the thing, sir.
But he is in custody. He says that give 2 months bail. I'll grant bail itself. Because see, after all, their wife and husband, some misunderstanding might have taken place. Where is 376 for that?
He has gone away for that only. This is the affair. Otherwise, nothing would there.
That's right. You just serve the lady through IO. Serve the lady through IO. Huh? Least the matter on Monday.
Yes, my lord.
Serve the victim through IO of the case. Least the matter. Okay.
My lord, I pray one, not Monday, one next day. I am not available on 23.
Sorry?
24.
24? Tuesday.
97 and 90.
97, 90. 97, 90. Yes.
99.
Yes, sir.
Petitioner is custody since 4/4/24, my lord.
4/4/24.
Charge sheet has been filed in the meantime on 9/6/24.
99 charge sheet.
Yes.
Charge file is certificate को मैं copy करनी charge file
Offense.
offense 370 34 366 342 368 372
Yeah. What are the
378.
allegations?
Allegation against the petitioner that they have helped the main accused ସେଦିନ ରାତିରେ ବର୍ଷା ଓ ତୋର ସ୍ୱାମୀ ବୀରେନ ରଜକ ରାଜୁ ରଜକର ଘରକୁ ଆସି ମୋତେ ତାଙ୍କ ସାଙ୍ଗ ଘରକୁ ନେଇଗଲେ ମୁଁ ସମୁଦାୟ ରାଜୁ ଘରେ 2 ରାତି ଓ 3 ଦିନ ରହିଛି କିନ୍ତୁ ମୋର ରାଜୁ ରଜ ସାଙ୍ଗରେ କୌଣସି ସରଙ୍କ ସମ୍ପର୍କ ହେଇନାହିଁ ରାଜୁ ରଜ ନଟ୍ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ସେଦିନ ରାତି 9 ବଜେ ପ୍ରକାଶ ସେଠି ପ୍ରେଜେଣ୍ଟ ପିଟିସନ 1 ଏବଂ ତାଙ୍କ ସ୍ତ୍ରୀ ଆସି ବର୍ଷା ଶାଶୁଘରେ ପହଞ୍ଚିଲେ ମୁଁ ସେମାନଙ୍କୁ କହିଲି ସୋନପୁର ଥାନାରେ ଆମ ଘର ଲୋକ କେସ୍ କରିଛନ୍ତି ଅନଲାଇନରେ ଫଟୋ ମୋତେ ଛାଡ଼ିଛନ୍ତି ମୋତେ ଛାଡ଼ିଦିଅ ନହେଲେ ତୁମେ ସମସ୍ତେ ଜେଲ ଯିବ ତା ପରଦିନ ପ୍ରକାଶ ସେଠି ମୋତେ ଗୋଟେ ରିଡିମି ମୋବାଇଲ ଟଙ୍କା 5,000 ଦେଲେ ଓ 11 ବଜେ ସାଙ୍ଗରେ ରେଳ ଷ୍ଟେସନ ମୋର ହୀରାଖଣ୍ଡ ବସେଇଲେ ଓ ଘରକୁ ଯିବା ପାଇଁ ମୋତେ କହିଥିଲେ The present petitioner Prakash Sethi and his wife.
Prakash Sethi and the wife.
My lord.
CD. Call for
Item 100. And I may
May I please, my lord?
CD. 1 week after.
2 weeks. Yes.
May I please, my lord? The occurrence took place on 16/1/2024, my lord. The petitioner is arrested on 23/4/2024, my lord.
23/4/2024,
my lord.
Yes.
My lord, charge sheet has been submitted on 30th of April 2024 for commission of offences punishable under section 498A, 304B, 306, 406, read with section 4 of the 4 of the DP Act, my lord. The petitioner is a husband, my lord. Husband, my lord. The cause of death is antemortem hanging, my lord. Subject to my lord's permit, my lord.
CD.
If my lord, if CD is not available, may I make a prayer? The case has been committed to the court of the Lenient Sessions Court. I may be allowed to renew my prayer before the honor the Lenient Sessions Court, my lord.
For the petitioner submits that the case is now committed to the Court of Sessions. Therefore, he seeks to withdraw the present petition to renew the bail plea before the Court of Sessions. With this liberty, the petition will be disposed of. Yes.
Well, after I will renew my prayer before the Lenient Sessions Judge, my lord.
Yes, I have done that. Yes.
Oblige,
May I please your lordship? May I please your lordship, ma'am?
Yes.
My lord, I am in custody since 9th May 2024, my lord.
9th
May. 21 kg of ganja. There are 3 petitioners. 21 kg.
9 May. CD is there?
Subject to incident.
CD is there?
No, CD is not.
CD, call for CD. Without CD, no. Yes. Call for CD 1 week. 1 week after 1 week. Yes.
Oblige, ma'am.
May please lordship, my lord. 392 offense. My lord, custody 2024.
23?
2024.
Yes.
They have arrested me lord in Remuna PS case no 101-110. Then they have to taken remand me lord in other 2 cases. And me lord in respect of the PS case number me lord 1 Remuna PS case number 110 and 112 already me lord I granted bail by this honorable court me lord. And me lord there is no legal material as because only my confession on suspicion police person me lord detain me.
What is the overtake attributed to you in this case?
In this case, only my confession, no TI parade, my lord.
Figure is there, yes.
Mobile phone, they recovery.
CD is there.
CD is there. But 8 incident is there.
7টা case পাইছি bail 392 তো confession ଗୋଟେ case ରେ
ତ ସେୟା problem ନା
ଗୋଟେ admission କରି they have arrested 1 case remand ରେ ନେଇଛନ୍ତି.
That is the whole difficulty in 392. You arrest in 1 case and keep on taking remand in other case.
ଦିଟାରେ bail ପାଇଛି ଗୋଟେ ମିଲର condition ମିଲର appear କରିବି ଥାନାରେ once a week.
March. What do you say?
Similar nature.
Similar nature, but he has already got the bail in 2 matters. 2 coordinate bench have given that bail. For 2. He's in custody since 48 days. conditional कर दो 6 months करो already into
103, my lord, due to a family dispute 307. My lord, already charge sheet filed, my lord, injured already discharged from hospital. Custody since 5/4/2024.
5/4/24.
Right.
Yes. Injury, nature of injury.
Gote grievous, dita simple.
Which part of the body? Oh, Pune. CD is there?
Yes.
Yes.
Family dispute, landed dispute are there, for which the relevant the assault was there.
Neck, grievous is on neck. On neck.
Neck.
Discharge already discharged.
What was the weapon?
Tangia.
Tangia and neck.
307 रे चार्जशीट है और रोलियाने 5-6 मास रोलियाने
Very lucky.
5-6 मास रोलियाने
He could have been beheaded also.
5 मास ऊपर रोलियाने
Accidents?
एक्सीडेंट किसी नहीं है यार नहीं एक्सीडेंट
Sure.
I have not shared it. Antecedent is not.
I have taken instruction, no accident.
File affidavit.
Hello?
File an affidavit that you don't have any.
That is
Where have you said that?
That I have specifically pleaded before the learned court below para 2.
Where is that?
That is page 13, my lord. The accused is having no criminal antecedent.
Are you related or what?
Yes, related to co-villagers, my lord.
They are co-villagers.
Yes, land dispute is there. That's how the case has been. Subject to verification कर दियो answer.
What do you say?
Subject to
Verification.
it लिखा है जी नहीं.
हाँ. This is also case. Allegation also the injuries. One injury. The victim has sustained 2 injuries, out of which 1 injury is stated to be grievous injury. Which is the cause in the neck of the injured by a tangia.
X.
In X, by an X. The victim has already been released.
Discharged.
Discharged. After first aid,
Again.
After first
On 17/4/2024, he has been discharged.
On 17/4/2024.
24.
Petitioner is in custody since 5/4/2024. This is a fight in the village amongst the relatives, relatives regarding head to the nature of allegation and period of custody, subject to verification of antecedent and to appear before the police for 6 weeks.
Obliged.
Yes, 104. CD?
CD charge sheet is submitted or it is not with me. The CD and charge sheet.
Medical report and everything is there.
I will bring it.
That's the order of the coordinate bench. Pursuant to the order dated 4/6/2024, the state council has not received the instruction and medical report and relevant documents. NC6 and relevant agent. Yes.
105.
I hear the petitioner is in custody since 22/5/2023, my lord. 22/5/2023.
CD required.
It's a 392 case.
CD court.
106.
Please, your lordship. So I'm in custody since 11/11/2023. In the meantime, my lords, charge sheet has already been submitted on 24th of December 2023 under sections, my lords, 417, 294, 506 and 376 to clause N.
CD.
I have got a certified copy of the charge sheet.
Give a copy of CD.
Short date may be given.
2 weeks, please.
107.
May I please, Lord? And petitioners in implication is on the basis of the statement of the co-accused, and the lordship also granted bail to other two accused persons, namely Rahul Ponda and Ramma Raulo. I have the order copy of those.
Yeah, you have
Yes, it's
report,
9 incidents there similar in nature.
case diary, autopsy report,
Yes, sir.
stage of trial, everything is there.
Yes.
28 witnesses were supposed to be examined. Out of
9
whom
incidents against the petitioner
8.
similar in nature.
No, petitioner has got one NDPS case. While he was in custody, this occurrence of this.
Whatever, 9 cases. No.
But he was in custody while this case was this occurrence was happened. And
the petitioner has 9 antecedent at this stage. Mr. Mahapatal and counsel for the petitioner submits that he would be filing a detailed affidavit giving the particulars of the cases the petitioner is involved and the stage of those cases. File an affidavit.
Yes, sir.
Yes. 108.
31 kilo ganja my lord. I'm custodian 17,124 my lord. 17,124 my lord.
24, okay.
31 kilo ganja my lord. I'm local man, no CA my lord.
CD is there. 18? 18,324. Okay.
And that 31 kg 200 grams.
31 kg, 200 gram. Okay.
Without a bag 30 kg.
Carrying that on soldier.
Antecedents, verification of antecedents. How many cases? How will you get out of it? You are already involved.
As per instruction, I have no incident.
CD is there. You verify how many. Land counsel for the petitioner to verify regarding the number of cases and regarding the antecedent for the petitioner, and would file an affidavit to that effect. These the matter. After 4 weeks. Yes.
My lord, while the petitioner is in custody in another case, my lord, he has been remanded in this case on 14/3/2024.
14 to
14/3/2024.
yes.
Offense is 419, 420.
तो अभी फटाफट होगा वहाँ पे क्या हम लोग समय कहाँ है हम समय में इतना पैसा कमाया
Yes.
Here allegation that while a man has gone to a ATM center, my lord, to
CD is there.
Yes, sir.
Yes.
Yes. Petition of item number 109 and 112. Common petitioner is there.
my lord, he was arrested in one case, my lord. And
How many cases you have?
the petitioner was arrested in one case and remanded in three other cases, my lord.
10 and 12.
Yes, my
In
lord.
both the cases, petitioner, counsel for the petitioner submits that he would file an affidavit giving some details regarding the antecedents of the.
My lord, I am ready with the affidavit, my lord.
Affidavit file.
Yes, sir.
Already filed.
Yes, I am ready, my lord.
File. And give the detail. Let us give the detail. What are the stages of the cases?
In all the cases.
No, you have to give what is the stage of these cases. Bail granted or not.
Yes, sir. A copy is there, my lord. Well, also.
Give the detail in the affidavit. These are blank affidavits.
All three cases are similar.
So therefore you give an affidavit. I'll take that, then I'll mention. Yes.
Item 112 also 109 and
110 and 112. Both.
Yes.
109 man. 109 and
109 and 112. Yes. 2 weeks.
My lord, next week.
The date will be given. You file an affidavit. In a table you give FIR number, says bail granted or not granted. 110.
Offense is 302 and the petitions are lady lordship.
CD is there.
No, CD is not there.
All for CD.
And CD is available lordship. The BLPL number 6723 of 2024.
67.
BLPL number 6723 of 24.
Tag.
Available. CD is available. The other co-accused filed the bail application. That CD is indirect.
When that matter is coming up? When those matters are coming up.
No, that coming the matter is unable justice. The matter is pending.
Then it has to go there. Then counsel for the petitioner submits that insofar as the bail application of co-accused persons are concerned, that's listed before the court in advance, and leaves the matter, leaves this bail application along with BLAPL number 6723.
Yes, Lordship.
6723 up to 24.
24.
20. Next. Huh?
It is there itself.
Huh?
It is there itself.
That's fine. It has to go there. Yes. Subject to permission of the honorable.
111. Case under section 467 and 420 of IPC. I have been jailed since 5.5 months, and in the meantime, charge sheet has been submitted. Prostitution case, Your Lordship, is like this. In 2019, I was an employee of.
When the charge sheet was filed?
Charge sheet, my lord, today I got instruction that it has been filed recently. This month.
Then renew your bail application was rejected earlier during investigation.
Yes, Your Lordship, that
Petition is agreed by the order dated 21/5/2024, where by the bail plea has been rejected. Subsequent thereto, charge sheet has been filed in the present case. Therefore, the petitioner seeks to withdraw the petition to renew the bail plea before the court below on the changing circumstances. With this, the petition is disposed of. Yes.
I may be pardoned, my lords. My lords, I'm appearing on behalf of the informant in item 111, my lords.
Yes, no problem. I record it. I have it. Yes.
Deeply.
13? 14.
114 can be permitted to withdraw.
Or withdraw.
115.
15.
Yes. Sir, my lord, petitioner is a lady in custody since 14/4/24 in connection with the magistrate tribal offence.
14,
because
4.
14/4/24, around more than 5 months. Because it is a magistrate tribal offence, allegation of theft of a gold chain, it was not taken. It was she has made an attempt, but was not successful. As it appears from the circumstances of seizure, and she is a lady, my lord. She is a lady and belongs to, because outside Odisha person, my lord, belongs
Outside
to
Odisha?
Bengal. Bengal, but she is now staying there for last 2 years, doing some small businesses. Both husband and wife staying there. Women, not men. Women.
Women.
That is from the petitioner the petitioner on the spot matter.
But circumstances.
Snatching, chain snatcher.
Mangal Sutra. He had only attempted. That case diary reveals she had made an attempt, but it's not successful.
Not successful. But how will you ensure her presence?
Pardon?
How will you ensure her presence?
Ensure, as your lordship please, any terms and condition, I will ask them to abide by your lordship's direction.
What should be the terms? Local security.
Local security, your lordship.
Local security. Without fail, huh? We follow. Also, allegation is presumption. The petitioner is a lady of 30, lady is over 30 years, over 30 years. She is in custody since 14/4/2024. The evidence form part of the charge sheet reveals that the petitioner had attempted to snatch the gold chain from the victim, unsuccessfully.
Yes, inside the temple. While this was making that.
Inside the temple unsuccessfully. And regard being head to the state council opposes the bail on the ground that the petitioner is a resident of Bengal. He presents in the court. She may not present in the court during the trial. And therefore, he submits that stringent conditions should be imposed. Regarding head to the information, it is granted bail. Subject to petitioner permission, local security, and she shall appear before the court every date of hearing without fail. And violation of any condition to maintain.
116.
Yes.
For an adjournment.
Adjournment.
Yes, sir.
Request adjourned. December.
117.
On behalf of Das Mayor, may I please also. The custody from Belgium, earlier granted bail by this court, and due to non-appear, the NBW has been issued. On the basis of NBW, I am arrested and custody since more than 5 months, madam.
Custody since
2/4/2024.
2/4.
2024.
When was the bail granted?
Page 12 versus kindly see.
Offense?
302, madam.
302. Again, you will.
No step taken on behalf of the advocate, madam. It is mentioned in the order sheet. मते कहला कि मु डाकिले आसीबे मते डाकी नहीं देखलो अनबिडल है मु कस्टडी 5 मास हला.
Where is that? It is alleged that the petitioner was quarreling with the wife of the victim and who happens to be the uncle of the petitioner.
The lectures of the advocate, I am in custody for more than 5 months. I am released on bail, page 12.
Yes. Then already bail was granted.
After refer the trial court each and every.
Yes. Petitioner was enlarged on bail by the trial court. By this court on 22/2/2017. While allowing the bail plea, where is that bail application number? Bail number?
Page 16, 12, my lord.
Number is not there.
7554 of 2016.
Huh?
BL appeal number
7554 of 2016.
16, my lord.
2016. However, when was the NBW issued?
Page 15.
However, he did not appear before the court below on 6/6/2017. No. On 18/1/2000.
Yes, ma'am.
18/1/2018. Therefore, NBW has been issued against him. Pursuant to the said NBW, the petitioner was taken into custody on 2/4/2024.
Ma'am.
24. Counsel for the petitioner on instruction submits that the petitioner would abide by the condition of bail without bail and shall appear before the court on its date of hearing. Regarding to the aforementioned, petitioner is enlarged on bail with condition of all conditions. Condition that we shall appear before the court. Yes.
118.
118, my lord, already acquitted.
Acquitted. Acquitted, huh?
120. The present petitioner is custody since 20th January 2024. In the meantime, charge sheet has already been submitted on 27/2/2024. Only 12 kilograms of ganja allegation.
27?
27/2/2024.
12 kg of ganja, custody from UDA with the condition and verification of antecedent is granted.
121.
121. Huh? Yes.
Yes, CD is there. 121.
CD is there. Yes. Yes, sir.
The allegation is he is in custody since 22/1/24. He was taken on remand. Nothing was seized from him.
What is the recovery?
Yeah.
Recovery?
500 kg was recovered.
Yes.
He was not at the spot. Nothing was seized from him.
Custody since
22/1/24.
Antecedent is there.
Antecedent is there.
Recovery antecedent.
Naturally, if he has been taken on remand means antecedent is there. But nothing was seized from him.
After material witnesses are examined, 6 months, whichever is earlier. Yes.
122.
Let me see. Let me see. Here he is in custody. Same happens with it.
122.
Same. Yes.
122 also same.
Just 1 minute.
Another.
Yes, किस नंबर देखो
Hmm? Same. Yes.
123.
May it please, my lord. My lords, herein Mr. Panda has been engaged to appear in this matter. He's on his legs at the moment. I'm praying for a passover, my lords. Deeply obliged.
124.
What is this matter? Cancellation of anticipatory bail. It is your petition. Cancellation of bail granted to the on the ground that the opposite party have assaulted the police when they appeared before the police station pursuant to the compliance of the condition. Okay. And there was bail condition. They were asked to go and appear before the police. They went there and created ruckus. And
Just once, my lord.
therefore, you have to act for it. Nobody is appearing.
Okay, cancellation.
Nobody is appearing. Hmm? 5, 6, 7 is not served. 1, 2 sufficient. Take first step to serve 5, 6, 7. Huh?
125.
These are those petitions, my lord, under Factories Act, my lord. AD return.
Yes.
AD has seen sufficient.
Sufficient. Yes. Service of opposite party is complete, but nobody appears on behalf by way of last opportunity. Yes. Service is complete.
Good. My lord, can it be taken up some other day?
Up to 2 weeks.
Interim order to continue.
126.
My lord, release of vehicle matter, your lordship, 457 CRPC petition has been rejected, your lordship. And recently, this honorable court directed to release one case, your lordship, and taking into consider in that case also honoring the accused, your lordship, that the case while the
Yes. Interim custody. Where is the impugn order? Show me impugn order. Show me the impugn order.
my lord, impugn order is, your lordship. It start from page 22, your lordship.
22. What does it say?
And operating part is, your lordship, page 32, your lordship. Taking into consideration Jitendra Kumar Digal versus State of Odisha, the learned trial court rejected my application, your lordship. That judgment has been dealt by this our honorable court in the case of State of Odisha by Registrar General Odisha High Court Cuttack in a division by your Chief Justice Court, your lordship.
Have you gone through this? See, relying upon some judgment.
Your whole case, your lordship.
Do you have a copy?
Yes, lordship.
Give it to me.
These two judgments are precedent now.
But
Your Lordship.
he is entitled to see, at least you should get copies. At least up to 1 week. Just check it up, huh?
My Lord, tomorrow.
After 1 week, tomorrow it will be very heavy. You should have given a copy earlier. Yes.
127.
Next week we would talk about it. 127. Yes.
127. May I please?
Yeah.
1 week time.
Yes.
1 week time, my lord.
Hmm?
1 week time, my lord. Actually, file that misplaced in
1 week.
Oblige, my lord.
May I please, your lordship? Instructions was sought for by your lordships. Your lordships are pleased to seek instruction from the state. Your lordship may kindly see the matter, my lord. Your lordship may kindly see Annex 2. The affair lodged by the petitioner number 1. Page 16.
It was last date of hearing. It was simply urgent anyway.
Yes. Therefore, my lord, your lordship was pleased to seek instruction from the state. State has to take instruction.
Whether any section under POCSO has been added in charge sheet or not? Section 8 has been added.
Charge sheet has been filed.
Yes, charge sheet filed. Section 8 has been added.
Then, my lord, your lordship may adjourn this matter, my lord. I will amend it by.
Then you file a fresh one. Taking fresh grounds and all.
No, ground is same, my lord. My ground is, your lordship, the judgment of Bhajanla. Your lordship may kindly see for a moment after.
Bhajanla, in one sweep you can't say Bhajanla, so it's past everything.
No. I am not saying.
See, you are challenging the cognizance order.
No. It was a fair, my lord.
So
Enter
if
proceeding. Only, my lord, I will bring the cognizance order to the record. That is the, my lord, I will again, my lord. So your lordship may adjourn it. I will bring the cognizance order on.
Request urgent. Yes.
129.
I may be permitted on behalf of Mr. Mishra.
Yes.
In the CRNC, I'm
Notice on huh? Yes.
Since I'm praying that the question of final report in respect to the petitioner, my lord, not the entire. Since I am a lawyer, I cannot be held responsible for the crimes committed by my client, my lord. There is a Supreme Court judgment also.
What are the allegations against you?
That is 420, 468, 471, 120B of.
Yes. On facts, what are the allegations?
And I don't identify the person who allegedly impersonated Indira Deheri, my lord.
What are the allegations?
Miller. I am placing the statement in Prashant Kumar Mahapatra. ମୁଁ ବର୍ତ୍ତମାନ ତହସିଲ ଅଫିସରେ ତହସିଲଦାର କଣ ସବ ରେଜିଷ୍ଟ୍ରାର ଭାବେ କାର୍ଯ୍ୟ କରେ। ଚଢେଇ ଗାଁ ମୋଦିଆରେ ଥିବା ଖାତା ନମ୍ବର 66 ଥିବା ପ୍ଲଟ ନମ୍ବର 66 କୁ ବିକ୍ରି କରିବା ପାର୍ଟିମାନେ ଆସିଥିଲେ, କିନ୍ତୁ ଜଣେ ଅବଜେକ୍ଟର ଥିବାରୁ ଜମି ରେଜିଷ୍ଟ୍ରି ହୋଇପାରୁନଥିଲା। ମୁଁ ସେ ନୋ ଅବଜେକ୍ସନ ଦେଲେ ଯେ ହବ ବୋଲି କହିଥିଲି। ତାପରେ ପଞ୍ଚାୟତ ପ୍ରମୁଖ ସାହୁ ଓକିଲ ଶରଦ ବାରିକ 16/1/21 ତାରିଖରେ ସେମାନେ ଇନ୍ଦ୍ର ଦେହୁରୀର ନୋ ଅବଜେକ୍ସନ ର ଆଫିଡେଭିଟ ସହିତ ସେଲ୍ଡିଡ ଡକ୍ୟୁମେଣ୍ଟ ଦେଇଥିଲେ ଓ ଜମିର ରେଜିଷ୍ଟ୍ରେସନ କରିଥିଲେ। କିନ୍ତୁ ସେଦିନ ମୋ ପାଖକୁ ସତ୍ୟବାଦ ଦେହୁରୀ ଜଣେ ବ୍ୟକ୍ତି ଫୋନ କରି କହିଲେ ଯେ ଇନ୍ଦ୍ର ଦେହୁରୀ ନାମରେ ଦିଆଯାଇଥିବା ଆଫିଡେଭିଟ ଜାଲିଆତି ଅଟେ। ତେଣୁ ମୁଁ ତାଙ୍କୁ ମୋ ପାଖକୁ ଆସି ଅଫିସରେ ଦେଖା କରିବା ପାଇଁ କହିଥିଲି। ଆଜି 19/10/21 ତାରିଖରେ ଇନ୍ଦ୍ର ଦେହୁରୀ ଓ ସତ୍ୟବାଦ ଆସି ମୋ ପାଖକୁ ଆସି ଦେଖା କଲେ ଏବଂ ମୁଁ ଓକିଲ ସରେ ପିଟିସନରଙ୍କୁ ଦେଇଥିବା ନୋ ଅବଜେକ୍ସନ ଆଫିଡେଭିଟ ଦେଖାଇଲି। ସେଥିରେ ଦସ୍ତଖତ ମୋର ନୁହେଁ ବୋଲି ସେ ମତେ କହିଲା। ତାପରେ ମୁଁ ତାଙ୍କୁ ଆଫିଡେଭିଟ କରିଦିଅ ବୋଲି କହିଲି। ଇନ୍ଦ୍ର ଦେହୁରୀ ଏକ ଆଫିଡେଭିଟ କରି ଦେଲା। ଯେହେତୁ ଓକିଲ ଶରଦ ବାରିକ ମିଛ କାଗଜପତ୍ର ପ୍ରସ୍ତୁତ କରି ଜମି ରେଜିଷ୍ଟ୍ରି ପାଇଁ ଦେଇଥିବା ତାଙ୍କ ବିରୁଦ୍ଧରେ ଆଇନଗତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ନିମନ୍ତେ ଲେଖି ପଠାଇଲେ।
Answer it now. All allegations are centered. Because you are the lawyer, you have done all this.
Tahsildar wrote a letter to the IIC.
Withdraw it, otherwise I'll have to write something, then it will be.
No, my lord, one more opportunity. will be
No, no,
given.
no.
Since Mr. Mishra is conducting counsel,
No, no,
we will
don't,
just
don't
stop
take all
adjournment.
silly excuses. No, no, please.
My lord,
Every time you
No, no, no.
try the luck and then.
First time I'm seeking for adjournment, my lord.
No,
Short
no,
adjournment.
I'm not going to adjourn. This matter has been pending since, see how many dates you have taken. And if you wanted adjournment, you should have straight away asked. When I express my opinion, you are asking this. But
No, I
this is
just
very,
said the
very
facts, my lord.
unfortunate. You are the lawyer. You have done everything. All allegations are centered against you. You tried. You argued. Once I express my opinion, you want adjournment. This is very unfair.
I'm sorry.
You can't
my
do
lord.
that. No, no, no.
I'm sorry, my lord.
I'll
Let's
then
sort adjournment.
judgment reserve. I'll write and you will face serious difficulty. I'll write a judgment and on this.
Permit
No,
me
no,
to
I
withdraw
can't.
the same. Permit me to
I
withdraw
can't
the
bear
same.
this kind of.
No, permit me to withdraw the same.
You withdraw, that's a difficult story. I'll write and on merits I'll write.
I'll
Your
file-
trial will be unnecessary. You withdraw and raise all the points before trial court.
No.
What is this?
File-
Then if you want adjournment, you simply say, I'm not prepared, you adjourn. It's all right, no problem.
I'm sorry.
Once the court express opinion about to pass the order, you say that adjournment.
I'm extremely sorry.
Yes.
My lord, and your lordship may permit me to
Yes, yes.
withdraw
I
the file
withdraw
back.
with all liberty to raise all the points at the appropriate stage.
Right.
And you are on bail. Are you on bail or not?
That I have not instructed. I have no instruction.
I am passing it over, you tell me after lunch.
My-
If you are not on bail
And-
because you are a lawyer, I'll try to
Since just now I
mold
received
it.
the
I'll try to mold the order in such a way at least you can come out.
pass it over.
But the order will be the same. If he is on bail, you just tell me. If he is not on bail,
Fine.
if he is on bail, it's all right. The same order.
Fine.
Pass over, same order.
Lordship, I filed for extension of time, Lordship.
Extension of
time, my lord. Extension of time for appearance, surrender before the learned court below, Lordship.
For the reasons stated in the application is allowed. The petitioner is directed to surrender appear before the court below on or before 15th of October. And remedies under. And the rest of the order passed on 6/5/2024 will remain same. Extended.
Deep.
15. Yes. Appeals. First time appeal? Hearing appeal. Okay, then hearing matter. Hearing matter.
137 and
137.
137 and 139. 137 mତେ instruction ପାଇଁ ଥିଲା ମୁଁ ତ contact କରିପାରିନି. 139
137 na?
and 139.
This is what?
This is my learning friend.
37 that minor, 1,800 rupees matter.
Oh.
Contacted his client.
Then I contacted, but what has happened, my lord, it was a bypass brief. One has given me.
What do you want next week?
No, next week.
Next week.
And 139 also, your lordship.
Interim order.
Entry order.
139 be interim order to one.
This is between brother, the division of.
It is a civil dispute that.
To seek instruction, otherwise you pass it.
No, I can't say, my lord. I will argue on merit because
That
unless and
will
until consent is given by my client.
Next week.
Next week.
Interim order to continue.
And 139 also.
39.
My lord,
Interim order to continue.
my lord, item 147 on behalf of Mr. Siddhartha Senior Counsel. He is out of station. Let it come tomorrow, my lord.
Not tomorrow. Not tomorrow. It will come. It is soon.
Tomorrow.
Not tomorrow. Question of tomorrow. Urgent to any day.
My lord, interim order to continue. Interim order is there.
But who is the other side?
Income tax.
And they will come and say that adjournment is taken behind our back.
I'll
That's the
inform.
problem.
Okay, I'll wait now.
Wait. Yes.
135 are procured some documents under the RTI. I'm filing an additional affidavit. Let it come up a week after.
Okay. Mr. William Kango, let us for the
First week of October.
seeks to file additional document in this matter. 135.
Copy भी, sir.
Copy, advance copy of the same shall be served on the file.
136, my lord.
One, yes, 153.
That is hearing matter, not
These are weekly list. Why are you asking? Let it be there.
136 my lord, I pray 1 week after.
136.
136 matter prayed for time to go through. Has been dismissed. The co-appellant has been dismissed from service. My learned friend, Mr. Mishra, senior advocate, Samir Mishra, he prayed for adjournment that I will take instruction from each client.
Instruction.
Unnecessarily, this is being listed again and again.
Weekly list. Put it in the weekly list. Yeah.
Oh, like.
Okay.
And also same 132 is also same. It is being listed. It may be put up in the weekly hearing list. 132. Why 132 being listed again and again? No paper, nothing.
2016 matter.
16 matter may be listed in the weekly.
Weekly. Technical problem. I am not able to follow what exactly is happening.
My lord, every time it comes, I don't know how it doesn't come now. We have done hundreds of cases, my lord. My lord, they allegate these, my lord called for the VAPL, and there's also a quashing application.
That there is the FIR copy is not there.
FIR copy, if the FIR is
there is no annexes. Therefore,
yes, my lord.
Numbered.
My lord, problem is this, my lord. How do I get the FIR copy, my lord, if they don't? They are supposed to be putting it in the public portal. If they don't do it. So therefore, I've quoted it, my lord. What else do I do?
Leaving apart the technical
yes.
You tell me, Mr. Ragada, if a accused is under your custody, if he needs medical attention, why can't you give?
That is correct, my lord. But what happened, my lord? The prayer for bail is rejected on 59 to 24, my lord. They have only given one slip, my lord. Not a detailed.
What do I do? Because
by the
I understand the technicality. Therefore,
my lord, by the JMFC, my lord. JMFC, they have to approach the sessions court.
Do a citizen needs to approach the court for the purpose of medical treatment if he is under your custody?
Medical treatment, they can file application before the concerned court.
My lord, I don't have to file. What is this? It's very sad.
Mr. Ragada,
very sad.
By the time they move application before court, that process takes place. Something serious may happen. So why can't you, without application, do you need a court order for that? He is in your custody.
Judicial custody, my lord.
My lord, I am telling with my lord with conviction. I'm stating before my lord as an officer of the court that the doctor in the jail has indicated that she needs to be taken because the suspects a fracture and immediately must be hospitalized. My lord, there are two. My lord, this is the police of the state. My lord, it embarrasses me to tell that I'm from this state, my lord. What happens, my lord, when this lady is assaulted, my lord, and the officer here, he is here right now. That officer, my lord, who's a 6th regiment officer, he is put behind bar. Below the rank of an SP, they can't even arrest him, my lord. After that, when they realize that the entire armed forces, all these officers of the rank, brigadier rank officer, my lord, all of them go. After going, my lord, they leave this person. And then they forward this person for the case registered against her is that that the derogation of duty, they didn't permit the officer to do. There are 7 people. He says they say that she assaulted. My lord, I have a pen drive, my lord, where when she goes, she has no injury. When she comes back, my lord, she is injured and now she has a broken jaw.
And still, my lord, this is the way they talk that I will be bound by law. My lord, which is the case of the Supreme Court that they entertained a 32 in a bail application. My lord, it's a very serious matter.
Matter is serious, but the technical, because of the technical.
Yes, my lord is not bound by my lord is a constitutional court. My lord can direct that the matter will be placed before my lord. I'm only saying.
Ask the registrar to see. I just want to, you get a report by 4 o'clock. Exactly what is the health condition of this?
I have to obtain a report instruction from the jail, my lord itself.
Yes, you ring up the jail. My lord, I am saying.
If he is a lawyer, the worry is twofold. One is, it appears to be a confrontation between the defense people and the police.
Yes.
This is one. Second is, the victim is a lawyer. This is second. So in these two circumstances, I want that you should speak to the concerned authority. Tell me what is the health status of the victim girl. If it is immediate attention is required today, then appropriate order will be passed. Otherwise, it will be listed tomorrow.
Yeah, and my lord has the power. My lord has the power on the 439, my lord, which is now 483. It's a concurrent power, my lord. The same as a 438, my lord. That not that, my lord, I cannot come before my lords against an order of.
No, there is no quarrel on that. He
Yes.
is also agreeing to that. But for
Yes, I'm only saying that my lord can either grant me bail, my lord, so that I get myself treated elsewhere.
I have the material. What are the things I don't know? I can't grant.
My lord,
perhaps I am only persuaded on this point that you need medical attention.
Yes.
Medical attention has to be given.
Yes.
And tomorrow, in any case, this matter has to go to the concerned court. It will go to the concerned court.
Yes.
For today's urgency, I just want to know what exactly.
My lord, let them say in 1 hour, my lord.
4 o'clock. 4 o'clock.
My lord, everyone. In fact, that officer is there. My lord, he's prepared to swear an affidavit. She has sent me a WhatsApp saying that the doctor has indicated.
Something wrong happens, we should not regret.
Absolutely. And
something wrong happens today, we should not regret tomorrow that it could have been done yesterday.
Yes, my lord. And we have been praying.
So therefore, please get the instruction.
My lord, I have also one more prayer, my lord. Let them take instructions. It's a very serious matter, my lord. All the offences are maximum 5 years, my lord. And why shouldn't the magistrate in the light of Anesh Kumar give judge the...
That's right. That will be...
that is a very serious matter.
That can be heard tomorrow, no problem. Today's urgency
Yes,
only
yes.
I want to know the health
Yes,
condition.
yes.
You please seek some instruction from the concerned people.
From the jail, my lord.
From the jail authority and tell me at 4 o'clock. If
My lord,
it is very, very essential, then...
My lord, the technical objection they are saying that the sessions court or judgment order is not there. I have not gone to the session court. I am come before my lord because of quashing and the other one matter, my lord. My lord has wide powers for quashing, my lord. My lord can grant bail.
Same court, my lord. 482, my lord.
482 also
But
there.
since both cases new law, my lord, for that sake,
The seriousness of the matter is this, my lord. Otherwise, I would have-
Health thing I'll take care.
Yes.
But tomorrow, in any case,
Yes.
that court
Yes,
will
ma'am.
function.
Yes,
It will go to tomorrow at 10 o'clock, sharp at 10 o'clock, at 10:30. The first item, I'll direct them to list.
My lord, let them take a
Get
serious
4
endeavor.
o'clock. Let us see.
My
the
lord,
health
I am prepared to. I can swear an affidavit here and now, my lord, of the saying that.
Let him get
Yes.
some instruction
Yes.
at 4 o'clock. Let us
Yes.
see what the kind of direction could be made.
Yes, deeply obliged, my lord. My lord, the other matter is not being listed because of that defect.
That
should
can
be-
wait for one day, no problem.
Yeah, but
So overnight urgency is not.
No, tomorrow for listing.
Tomorrow it will be listed.
Yes, with defect, my lord.
I'll give a direction
Ah.
that tell the district list it with the
List both the matters
concern.
with both the matters.
By tomorrow is a first item. Okay. And today you let him seek health position. Yes.
Okay.
49.
Yes.
My lord, 138 NI Act matter, my lord.
Yes.
My lord, a private party without, I am a dealer, my lord, selling the tractors. During the COVID-19, I could not sell the tractors. And PDC was dishonored due to non-sufficient of funds.
Then what to do?
I pray for my lord, that tractor is also pending with me,
But you have issued check.
my lord.
Then
But
it
due
is
to
not
non-selling, I could not able to.
Whatever may be the reason you have issued check, it is got dishonored. What this
The
court
tractors which did not sold by me is also pending with me. I have also requested him to get back the tractor, and I may not be.
These things I can't do it, no? I can't do it. You should have.
Your lordship may issue notice, madam.
Better you should go to trial court. I'll give direction to the trial court to send for mediation. And
my lord, here is the mediation, my lord, possibility mediation, my lord. Your lordship may issue notice, then I will sort out.
there is nothing in 138. How can I issue notice? There is nothing. If some legal issue would have been there, I would have been entertaining this petition. There is no legal issue. You say that you have given PDC because you could not sell the truck, so therefore you could not pay the money. Therefore, PDC were attempted to be encased. What to do? I am giving you liberty. You move application, appropriate application before the court.
My lord,
and trial court will try to send it to mediation.
Here is the mediation. I want to solve the matter before this honorable court.
So issue notice to the court.
Only, ma'am.
May I please ask? Here the petitioner before lordship is aggrieved by the order under annexure 1, madam.
Yes.
Page 13, starts from page 13.
13.
Thereby rejecting, yes. Thereby rejecting my petition filed for sending the all the admitted signatures of the accused and the contents and signature appearing on the check as well as the invoices which the complainant is basing relying upon. The complainant's case basically stands on the issue that in respect of those invoices, the products were delivered and I issued a check. My contention before the court below, and the trial court, that the check was given as a security check. That contents were not filled up. And for your lordship also, I have got the deposition copy of that complainant. He admitted. He's two types of statements he's giving.
I am not here to either accuse you or
no. I am not saying there also that. My limited prayer that let the signatures appearing on the check as well as the admitted handwriting of
have
the
you, have you admitted the check or not?
Check signature I admitted. But the contents I have not admitted.
That will be
another thing.
You have to show me complainants.
That I am showing.
Show me. Have you confronted with the check?
Yes.
What he says?
Page 3, your lordship.
But that's all.
4.
You can only confront. That's all.
No, page 4.
Beyond that, you can't do anything.
No, my lord, kindly see page 4.
Yes, I am there.
Last, the details. Last sentence, Aramboj.
Yes.
The details of the check was entered by the accused as the check was presented to us being duly filled up. Next, my lord, next. The accused had not entered the details on the check before me as it was presented to me to fill up. But the contents of the
why should the witness, you confronted the witness, is agreeing to that. Your purpose is solved.
Another question was there. With
but
regard
your
to
purpose is served.
No.
By this question.
Another question was also another question was there.
Your defense is admitted by the complainant. Everything is done.
No, but that is not.
Now you argue finally on the basis of this confrontation.
I have not entered into the. At the time of entering into the defense, this is my first petition to send the documents for handwriting expert and the checks.
This is the court statement.
Yes.
In the court, you have confronted the check.
Yes.
You asked the question.
But the invoices
is also mine.
But
it was given on security.
Yes.
The content of the check was filled up by the complainant.
No, accused. He's saying that accused.
Sorry, accused.
Yes.
Accused. That was you put it to the accused.
Yes.
And he has admitted it.
But I have not filled up the contents.
He has admitted. This position is admitted. This position is already admitted on record. You have not filled up.
No.
What else you need?
No, perhaps I am not.
No, I'm
not properly read. Your lordship, 1 second, I'm reading. For your lordship satisfaction, 1 second, I'm reading.
I'm already satisfied.
The details of check was entered by the accused.
He is saying.
You have already confronted with that.
And for that purpose, my lord, I am relying upon two decisions. One is Kalyani Bhaskar, two is
accused
that
statement.
Ranga.
Accused statement. That is accused statement.
Check mu sign kartili.
I am not disputing.
To know the
I am not disputing.
ascertain the age of the signature, I have given the citation. Your lordship.
Age of the signature, handwriting expert can't say.
So your lordship should, our High Court decision should be there. Your lordship should, may I pray before your lordship that your lordship.
Well, I am relying upon.
Don't have anything.
No, I am relying upon two decisions of the Honorable Supreme Court in case of that Kalyani Bhaskar, reported in 2007, 2 SCC, page 258.
That says that signature
12,
admitted.
What does it say?
Page 12, paragraph 12. Section 243, section 243(2) is clear that magistrate holding an inquiry under CRPC in respect of an offence.
Come to the point. What is the ratio?
And I have marked it. It is essential that
this judgment is against you only, which you are reading.
No, man.
Just read it. 263 page.
260.
The learned magistrate shall take appropriate steps to obtain the report of the handwriting expert on the point whether the signature on the check is that of the accused. On that point, handwriting expert opinion is required. That's what the court says.
Yes.
And in your statement, you say the signature is mine.
No, I am saying that I am saying that my signature on the check is mine. I don't dispute.
That is what is the judgment you are saying.
But that check was issued. I was also advancing an argument in another case.
Judgment is against
so
you. The judgment which you cited is against you. Next judgment.
No. Next judgment is that T Nagapa.
Nagapa. Which part? You have not read the full judgment.
Paragraph 7.
7, yes. You can't read the one line somewhere and say that you have to read the entire judgment.
Paragraph 7.
7.
When a contention has been raised that a complainant has misused the check, even in case where the presumption can be raised under section 118A and 139 of the Act, an opportunity must be granted to the accused for adducing evidence in rebuttal thereof. As the law places the burden.
See, 139 is a rebuttable presumption.
Yes.
And the presumption, because merely you have signed the check, presumption goes against you. And you have a rebuttable presumption.
But I have signed the check against in respect of the any debt, in respect of the debt. That debt, the case of the complainant based on the statement signatures available on the invoices.
Only one line. Your lordship.
Invoices.
See the past
in the invoices, your lordship will say.
Past judgment.
I understand.
No, another thing, your lordship, I have not come to that.
Past judgment.
The invoices which the complainant is relying upon to file his case or to raise the debt against me, that those invoices I have not signed. I have not received those products.
Page 2.
The signature, my signature, forging my signature, that was produced before the court.
In reply,
that is also there. In my petition, I have stated everything before the learned magistrate. Very short petition, I have stated everything.
Para 7, page 225. What my learned friend says, this court, your lordship got 225, the first decision. The first decision, S. Gopal versus D. Balachandran, page 225, para 7.
Yes.
This court in Rajendran versus Usarani 2001 LW Criminal 319 has observed that no law prescribes that in case of any negotiable instrument, the entire body of the instrument shall be written only by the marker or drawer of the instrument. Once the execution is admitted, it shall be taken that the check was issued by the accused in favor of the complainant.
Obviously, suppose MD of a company,
exactly,
he will not fill up the check and all.
Your lordship was
clerk and everybody will do, they will sign it.
And the same has been reiterated in the subsequent decisions. Your lordship may kindly have a glance. What my friend is submitting.
Another judgment.
He has not filled up the entire.
Another decision I am relying upon that.
Judgment reserve.
This decision may kindly be taken note of. That decision of the Yes. Yes. No. It is not going against me. Paragraph 7 of that judgment.
7.
Yes. Therefore, the accused did not dispute the issuance of check. but he has disputed the age of the ink and contents found on the check at Exhibit P1. The accused has only denied the factum of the amount, and the said check issued by the accused is the year 2011, and the contents found on Exhibit P1, which is alleged to have been written in the year 2014. That is with regard to the age of the signature and the check.
Yes.
There, your lordship will find that ordering portion is at after paragraph 13. The impugned order passed by the learned trial court in CC number such and such is hereby set aside. Consequently, the application filed by the petitioner accused under section 45 and 73 of the Indian Evidence Act stands allowed, even to the scope and object of section 293(1) and 293(4) CRPC. The consideration of the said application filed by the applicant accused are concerned, it is relevant to stipulate that conditions such as the trial court CC number shall secure both the complainant and accused, and their presence and the disputed check at Exhibit P/1 shall be forwarded to the concerned forensic science laboratory for the purpose of examination or analysis, and with a direction to submit a report to the court in a sealed manner. The trial court in CC number is directed to fix the expenditure of on the petitioner accused for sending the disputed check Exhibit P/1 for examination or analysis from the concerned FSL wherever he desire, as maintained by the government. Here, my case, my petition before the learned magistrate, your lordship will find my petition. I have enclosed that my petition. That petition is available at page 23, my lord. I have written everything. Very short petition, but I have written everything.
Karnataka High Court. Yes.
In order to remind your lordship, I am again referring to page 15, running page 15.
I will read it.
Yes, my lord. I am further I am submitting that after this rejection of petition on 30th of January 2024, the accused filed another petition under section 73 of the Evidence Act. That has also been subsequently rejected. And this case is lingering since 30th of January 2024 for defense evidence. And this is so my prayer is, your lordship may, if your lordship pleases to dispose of it, your lordship may target this.
No, his petition, why should you?
Only defense evidence.
This is the last decision.
My prayer.
Lordship can't have a class, but your lordship keep it. Just.
Why are you giving in installment?
No, installment. Gotta for gotta degi place kore abhi tara muta pura.
Punjab and Haryana. Which paragraph?
Paragraph 12. It starts from paragraph 12, but I will not read the entire because it is a lengthy. Paragraph 14. Paragraph why I am showing this decision, because question may arise, and your lordship was also aware about the decision rendered recently in case of Bir Singh.
Paragraph 14, please.
Page 30.
30. Yes. Yes. Nakapa.
Para 13. Para 13. Para 13 so for the judgments of Honorable Supreme Court, Bir Singh case, Supra and the sympathy such and such are concerned, those judgments do not deal with the issue of examination of the check by an handwriting expert. The only reiterate the settled position law that the signatory of the check need not fill the body of the check for the check to be valid check. Thus, two judgments do not further the case of the complainant in any manner whatsoever. This court in Messrs. Indo such and such 1981 year has held that where there is conflict between two judgments rendered by the benches of equal strength, the courts are required to follow the judgment which appears laid down more elaborately and accurately. In my opinion, the judgment in T. Nagapa's case, Supra, lays down the law more elaborately and accurately than the judgment of Bir Singh's case, Supra, which only reiterates the position of law that the signatory of the check need not fill up the body of the check for the check to be valid check.
Yes.
The petitioner accused shall examine the handwriting expert as a defense witness within a period of 4 weeks. The direction was given there. So I just placed the last decision because if the question will arise to come to your lordship's mind with regard to Bir Singh's judgment.
You can also get the private handwriting expert
No,
and
no.
exhibit it.
No, handwriting expert, there is no private handwriting expert.
1001. 1001.
No, that cannot be admitted, accepted by the court.
That defense evidence you can you can get this handwriting expert report,
but
and cite him as a witness.
The T Nagapa's case is very elaborate, very clear. Your lordship, I pray your lordship to deal with that.
Specifically, the petition was filed to know the age of the ink. Only the lower court.
He has a judgment of Karnataka High Court, which says that age for the purpose of ascertaining the age of ink also it can be sent.
I have cited 4 citations. The Gujarat High Court and this Madras High Court. I have given 4 citations.
Our High Court doesn't have any view.
So that I am praying that your lordship should AFR.
We'll see.
Then my petition is there at page 23.
I will read.
What was the
24 is the prayer. Page 24 prayer. Age of the ink.
63.
I read judgment reserved.
If you want to give written note also, you can give.
On behalf of Mr. Tripathi,
Written note, if you want to give.
I will give it by tomorrow.
Item 63 on behalf of Mr. Tripathi, your lordship, let it come tomorrow. Is
Not tomorrow. It will come at its own way. Time.
73.
It will go to November last. May I please?
Custody since 21/12/23.
Bail. 21?
21/12/23.
Yes.
Charge seated under section 498A, 304B, 306 of IPC read with section 4 DP Act.
Yes.
A case of hanging, my lord, she locked the door from inside and committed suicide in absence of the petitioner.
Yes.
He is the husband, my lord. Marriage was within 1.5 years. That the deceased has a 45 days child. He is the husband. Why she has committed suicide, my lord? And the PW, the informant, other witnesses, they were examined. They have stated that there is allegation of dowry demand. PW.
How she died?
My lord, due to hanging. My lord, due to hanging, antemortem hanging is there. There is only ligature mark. There is no any other mark except ligature one. But my question, you have a person, she will die leaving behind a 45 days child, and he is the husband. He is not morally responsible for that.
You were there at the time of
No, I was absent.
When the charge sheet was filed?
Charge sheet submitted on 12 to 24. My lord, witnesses stated that pre-occurrence and post-occurrence present petitioner was there. Not see he come after that post-occurrence. Pre-occurrence, he was there. Post-occurrence,
the problem is that there is
No, I was not present at the time of occurrence.
So many
yes, it is the investigation
Show
disclosed.
me any document that you are not present at the time of. Read out. See, except the rejection order, you have not filed anything.
No, I have filed subsequently, man.
FIR is also not. Evidence is
I
there.
have filed
Yes.
subsequently.
Which evidence you want me to read?
The investigation of the IO, my lord.
PW, you tell me now.
Investigation of the IO.
My lord, may I read one statement, 161 statement of the relative of the present petitioner? That is relevant person.
Who is?
My lord, is Joy Sen Sahu.
Joy?
Joy Sen Sahu.
Yes.
Relevant person I am reading, whether he was present or not. ସେଦିନ 20/12/23 ମୁଁ ଆମ ଗ୍ରାମ ଲୋକମାନଙ୍କ ସହିତ ଭୋଜି ଖାଇବା ପାଇଁ ଯାଇଥିଲୁ, କିନ୍ତୁ ପରେ ମୋ ସ୍ତ୍ରୀ ମତେ ଫୋନ କରି କହିଲା କି କସ୍ତୁରୀ ସାହୁ ମରିଯାଇଛି। ମୁଁ ଏଇ କଥା ଶୁଣି ସଙ୍ଗେ ସଙ୍ଗେ ଘରକୁ ଆସି ଦେଖିଲା ବେଳକୁ କସ୍ତୁରୀ ସାହୁ ମରି ପଡିଛି। ତାପରେ ମୁଁ ମୋ ସ୍ତ୍ରୀକୁ ପଚାରୁ, ସେ କହିଲା କି କସ୍ତୁରୀ ସାହୁ ଲୋକନାଥ ସାହୁ ଇଜ petitioner. Informant and petitioner both are name is ଲୋକନାଥ ସାହୁ। ତାର ଛୋଟ ଛୁଆକୁ ପୋଲିଓ ଖୁଆଇବା ପାଇଁ ଯାଇଥିଲେ ଏବଂ ଘରକୁ ଆସିଲା ପରେ ସେମାନଙ୍କର ବହୁତ ପାଟିତୁଣ୍ଡ ହେଲା। ପାଟିତୁଣ୍ଡର କାରଣ ପଚାରି କହିଲା କି ବିବାହ ପାଇଁ ଗ୍ରୁପ ଲୋନ ଉଠେଇବାର ଥିଲା, କିନ୍ତୁ କସ୍ତୁରୀ ସାହୁ ମନା କରିଥିଲା, ସେଥିପାଇଁ ସେ ଦୁହିଁଙ୍କ ଭିତରେ ଝଗଡା ହେଲା। ତାପରେ ମୋ ପୁଅ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ବାହାରିକି ଗଲା ଓ କିଛି ସମୟ ପରେ ପୁଣି ଆସିଲା ବେଳକୁ ଦେଖିଲା ଯେ କସ୍ତୁରୀ ସାହୁ ବେକରେ ଶାଢୀ ଲଗେଇ ଆତ୍ମହତ୍ୟା କରିଛି। ସୋ ଇନ୍ ଦ post occurrence and pre occurrence he was present.
What do you want to show?
And my lord, the deposition of PW5, who is the informant.
PW5.
My lord.
Yes.
Since 1.5 years of the marriage, the deceased took place with the accused. Due to non-fulfillment of demand dowry, deceased was killed by the accused. PW5.
That is on suspicion, my lord. That report says he was not present at the time of occurrence, and there was not a single injury found on the body of the deceased.
No,
Except that ligature mark. Except that ligature mark, my lord, there is no injury.
3, 4, 5, 6, 7, 8 witnesses have been examined by eight witnesses. That petition is agreed by the order dated 11/3/2024, whereby bail plea has been rejected. Subsequent thereto, there are 8 witnesses which have.
If there is any assault, my lord, there must have been some injury.
8 witnesses have been examined. In view of the changing circumstances, petitioner should review the bail plea of the trial court. If such bail plea is removed, the same shall be considered within 15 days. Yes,
A clear case of 306, my lord. There is no injury at all.
15
my
days,
lord.
see all the evidences which has come on record, that trial court has to see.
Consider.
Yes. Next.
74.
Lordship, I have instruction to appear in this matter. Lordship, pray for 2 weeks' time, Lordship.
Yes.
Oh, bless.
26.
May I plead your lordship? The petition is in custody since 23/12/2023, your lordship.
23/12/2023.
In the meantime, charge sheet has already been submitted. Allegation under section 302 and 498A. The petitioner is the husband. 302 to 498A.
Charge sheet filed on?
Charge sheet preliminary charge sheet was submitted on
19/4/2024, your lordship.
Rejection order is 19/4.
19/4/2024.
You go to trial court.
Rejection order is 13/3/2024.
Petitioner is agreed by the order dated 13/3/2024. Subsequent thereto, on 19/4/2024, charge sheet has been filed. In the changing circumstances, petitioner should renew the bail plea before the court of first instance. Hence, liberty is granted to the petitioner to renew the bail plea before the court.
Because there was no eyewitness, your lordship. Only on suspicion I am being implicated, and I am already in custody for more than 8 months.
That's right, but during investigation you moved the application. Now charge sheet is filed.
Nothing came out.
Next. Yes.
82.
My lord, 82 that 200 kg ganja was seized. Who accused person was not surrendered. For that reason, your lordship.
In the petitioner was granted interim bail for a period of
4 weeks.
4 weeks. On
That is
35/2024. Non-APS on second call. Non-APS on second call. Petitioner was granted interim bail for 4 weeks on 30th May 2024. The surrender certificate has not yet been filed. Mr. Mishra, for the state also submits that the co-accused persons, those who have got interim bail, have also not surrendered. Therefore, not surrendered. Therefore, their bail application was also rejected by this court. Regard being had to the aforementioned, the bail application is rejected. Trial court is directed to issue appropriate process to ensure the presence of the petitioner before the trial court. Yes.
93.
May I please, your lord?
Yes.
Admittedly, there was no eyewitness to the occurrence, and on the ground of suspicion, the present petitioner is in custody since 27/12/2023.
27?
27/12/2023.
Yes.
Charge sheet has been submitted. It is suspected that the present petitioner has illicit relationship with the wife of the deceased. For that reason, the petitioner, my lord, even if some of the witnesses have been reported before the magistrate that they have not known the occurrence.
In
During
this case, my lord, actually the petitioner is the brother-in-law of the deceased, my lord, and the petitioner having extramarital relationship with the wife of the deceased, my lord. On the date of offense, the deceased brought some fish to the house and asked the wife to cook the
No,
fish.
petitioner is the brother-in-law, Sala,
Yes.
of the deceased.
Deceased.
Okay.
Sorry, my lord, Bheni,
Bheni.
brother-in-law.
And there are my lord, the petitioner having extramarital relationship with the wife of the deceased.
Okay.
On the date of occurrence, it is alleged that deceased brought some fish to the house and asked his wife to cook it. But since there is a quarrel, on the same day, this the wife of the deceased telephoned to the present petitioner. The present petitioner came there, and accordingly in the night they committed the murder. Though there is no eyewitness to the occurrence, but in fact about the informant, my lord, what happened, my lord, after the next morning, the son of the deceased told to the mother that where is my father? He stated that your father went somewhere else. Thereafter, after some days, villagers found a
Dead body.
Dead body, my lord, tagged with the bag, my lord, and floating in
Gone
the river, my lord. When this matter came to knowledge of the wife and that this petitioner, my lord, what happened? The wife went to the police station, lodged a missing report. In the police, my husband since long is not in my house, my lord. On the same day night, this petitioner taken the dead body from that canal, went to inside the jungle, and they cremated the dead body. By the time one Gagan Naik seen the while cremated dead body,
Why have you done that?
Gagan Naik, my lord,
Your lordship may kindly see.
Gagan Naik
statement.
accordingly, the FIR registered.
Your
Gagan Naik
lord-
stated that, my lord, I am stating. Gagan Naik, আজি তার 16/12/23 को आपण आके बयान देबार एक जे स्वरूपा ग्रामर चंद्रमणि सुनानी दी पिटिशनर तार सळा उमाकांत बाघ को मारी देबार मु जानि अछि उमाकांत बाघर शव को चंद्रमणि सुनार पोड़ी देबार मु देखुछि मु ए घटना देखिबार चंद्रमणि सुनार मते जीवन नु मार देबाक धमक दे देयर आफ्टर ही लॉ
But soon after
He is the informant.
informant.
Yes,
But
see, my
soon after the occurrence, the alleged occurrence was taken place. Your lordship may kindly see 1 month before. Alleged 27/11/2023. FIR was registered on 26/12. He has not disclosed that on which date he has seen, on which date.
The daughter of the
Petitioner is accused also. I have finished the evidence form part of the charge sheet. And charge sheet, I am not inclined to bring the bill of petitioner at this stage. However, liberty is granted to the petitioner to remove the bail after the material witnesses are examined. If material witnesses cannot be examined within 6 months for any reason whatsoever, he may remove his bail.
Your lordship may kindly Your lordship may I pray one thing, my lord. The state government may be directed who was the material witness. Even if admitting the statement of the said Gagan, the son was never examined.
And the trial court is directed to examine the material witnesses preferentially over the formal witnesses. Yes. Next.
123.
120. Yes.
Please, my lord. Lords, here the petitioner assails the impugned order of the learned special judge, wherein he has rejected my prayer for being released under section 167(2) of the FIR. That is order dated 26/2/2024.
Yes.
Annexure 1.
Yes.
Now the facts are like this. The petitioners, before your lordship, my lords, they were arrested and were produced and remanded on the date of the FIR, my lords. That is on 30th of August 2023.
Yes. Arrest.
So as per the NDPS Act, my lords, 36A, the investigation is required to be completed within 180 days. The Act also gives a discretion to the investigating authority. If it is not able to complete the investigation,
Seek extension.
to move the court and seek an extension. Now, what happened here is that the 180th day period expired on 25th of
February 2020.
25th February.
25th to 24.
Hmm?
25th to 24.
Mile.
Yes.
Now your lordship may kindly look at annexure 3, the charge sheet. That's at page 27 of the.
Yes.
Now this charge sheet, your lordship may see the first page on the top left-hand corner, the endorsement of the special judge.
Now, see that. Which page? Page
Well,
number?
page 27.
Page 27.
Right side above top.
Yes.
26 to 20.
He has signed and endorsed on 26 to 2024.
Yes. 26 to.
My lords. Then my lords may kindly look at page 33.
One day after.
No, my lords may kindly look at the last page of the charge sheet. What the IO writes.
25.
Page 33.
Yes.
He writes, during course of investigation, visited the spot, examined complainant and other witnesses, recorded statements, seized seizure lists, all these things he writes, my lord. Your lordship may see in the middle of that paragraph, the sentence is, this case was supervised by Sri Nitish Wadhwani IPS. Has your lordship got that?
Yes.
SP Malkangiri, and pray for orders to submit charge sheet under section 20B2C, 27A and 29 NDPS Act against the accused, namely Pratham Patra alias Ghatak, Bidhan Biragi, son of Vipul, and under section 20B2C and 29 NDPS Act against accused Ranjit Malik, son of Madhav alias Sudeep. And after complying with all the instructions imparted in the supervision note, submitted FCR to SP Malkangiri and received order for submission of charge sheet under 20B2C, 27A and 29 NDPS Act against the accused, namely so-and-so, 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 keeping investigation open as per provision under 173(8). My submission, my lords, is that in
But
terms...
the signature, the down below is 25.
Yes,
25.
I am not disputing that. My submission is that this gentleman, the IO, as well as his supervising officer, the SP, was probably not conversant with the provisions of the NDPS Act. The NDPS Act gave them opportunity to have the investigation period extended. It was not required for them to hurriedly file a charge sheet and keeping investigation open as per 173, because they could have easily approached the court, obtained Millard's orders and got an extension. In any event, although this charge sheet is signed on 25/2/2024, it was not placed before the court on that day.
Yes.
And it has been placed on the next day when the 180-day period is over. So therefore, my lords, my submission is that learned special judge erred in holding, my lords, that I am not entitled to bail under the special provision, my lords, because the charge sheet has been submitted. Where was the charge sheet submitted on the 25th? Since it has not been placed before him, nor he has endorsed that it was placed before him on the 25th, it is to be held that the charge sheet was not there on the 180th day.
This order was passed on 26th February.
Yes, Miller.
You moved the application.
I moved on the 26th.
That day the charge sheet was there.
On that day, the charge sheet was there.
Filed before.
Yes, it should have been there the day earlier.
As per this rejection notice, he is entitled for bail. But your lordship may call for a report from the session court. Because the endorsement that is on 26, what in the Xerox copy has 5. And my lord, kindly see that page 27, my lord.
27.
27, my lord. That annexure 3. And on scene, that is 26. Another was 26, it was overwriting. 26 to 24, scene, then signature of the special judge. Then, my lord, 26 to 24 also another date, which was overwriting. So your lordship may call for a report from the session court that on which date the charge sheet was actually submitted. And in the meantime, I also, otherwise, as per the order, he is entitled for.
This is the seal and signature.
Is
The
26.
Date is very clear there.
My lord, first above that 26.
Above it is not visible to me. It is not coming here.
And below, my lord, 26 is override.
This is not there here.
No, he has annexed that.
No, the photocopy it is not visible here.
It's there in the certificate.
Because my lord, what happened in earlier, my lord, what happened on that basis, 40% were enlarged on this 167 default base. Subsequently, my lord, when the original copy was called for, at that time the date was manipulated. So the recall petition was filed, their bail petition was.
Yes, you are saying this date.
My lord, that is.
But the
above is 26.
Overwriting also it is 26 only, it's 26. Not 27 or 25.
So your lordship may call for a report. In the meantime, I also obtained that charge sheet copy and other materials. Otherwise, he is entitled to.
Honda, then counsel for the petitioner submits that the petitioner was arrested on 30th August 2023. Therefore, by 25 to 2024, 180 days mandate under law for the purpose of filing the charge sheet had expired. However, on the very next day, that is on 26th February 2024, the charge sheet has been filed. Therefore, the petitioner is entitled to the statutory benefit contemplated under section 167 bracket 2 CRPC. The perusal of the charge sheet reveals that though the investigating agency, investigating officer has signed the charge sheet on 25 to 2024, but appears to have presented the same on the next day, that is on 26 to 2024. The signature at the top of the charge sheet, certificate copy of the charge sheet, where the special judge has endorsed the charge sheet, indicates the date of 26 to 2024, but below that below the signature, there is another date. There is a date. The date of 26 to 2024 is mentioned. However, there is a certain overwriting. Therefore, the counsel for the state submission that it would be appropriate if a report is sought from the trial court. In view of the aforementioned, the special judge Malkanagiri is directed to submit a report by within a week regarding the exact position as to whether the charge sheet was filed on 26 to 2024 or on 25 to 2024. Reach the matter Monday. Next Monday.
May I play one thing?
Yes.
If your lordship is calling for a report, let him transmit the order sheet of the record also to your lordship. It can come.
The trial court is also directed to transmit the entire proceeding.
My lord. Your lordship may post it to 26.
Proceeding presented.
My lord, two judgment is there. One is including the date of arrest, another is excluding the date of arrest. First was the excluding the date of arrest. If it will be counted, then.
But in 26 he was entitled.
26 is entitled.
25 is something different, but 26 he was entitled.
Can I pray the matter be taken up on 27?
27.
And in the recent judgment that the date of arrest will be included on that day. So if it will be included 25th.
If some benefit is to be tilted in favor of the accused, it has to be given. That's all.
And if
a report comes, then.
My lord. And if one day will be excluded, then 26 is the last date.
27. Huh? All the matters. Yes.
131.
One 29. 129 is passed.
120. What happened? He was on bail?
No, petition is not on bail, my lord. But my lord, I just like to submit 2 lines, my lord. That is, your lordship says statement of page number 31 and page number 32, my lord. That is, may I read out, my lord?
Yes.
ମୋର ନାମ କୁନୁ ପ୍ରଧାନ, ପିତା ପରମେଶ୍ୱର ପ୍ରଧାନ, ଥାନା ବରଗଡ଼। ଆଜି ତା 20/10/2020 ତାରିଖ ଦିନ ଆପଣଙ୍କ ପାଖରେ ଦେବାର ମୋର ମୌଖିକ ଜମାନବନ୍ଦୀ ଏହିକି ଯେ ମୁଁ ବରଗଡ଼ କଚେରୀରେ ନୋଟାରୀ ଭାବରେ କାର୍ଯ୍ୟ କରେ। ମୋର ନୋଟାରୀ ନମ୍ବର 1794 ଅଟେ। ଗତ ତା 16/10/2021 ତାରିଖରେ ବରଡୋଲ ଗାଁର ଓକିଲ ଚନ୍ଦ୍ରଘୋଷ ବାରିକ, ଚନ୍ଦ୍ରଘୋଷ ବାରିକ ଏକ ଆଫିଡେଭିଟ ସହିତ ଜଣେ ବ୍ୟକ୍ତିଙ୍କୁ ଧରି ମୋ ପାଖକୁ ଆସିଥିଲେ। ତାଙ୍କୁ ମୁଁ ନାଁ ପଚାରିବାରେ ସେ ଇନ୍ଦ୍ର ଦେହେରୀ, ପିତା ସ୍ୱର୍ଗତ ଅର୍ଜୁନ ଦେହେରୀ, ଥାନା ବଟଲି। ତାକୁ ଓକିଲ ଚନ୍ଦ୍ରଘୋଷ ବାରିକ ମଧ୍ୟ ଚିହ୍ନଟ କରି ଆଫିଡେଭିଟ ରେ ଦସ୍ତଖତ କରିଥିଲେ। Chandradhosh Barik have identified as he is the one Indra Deori. I have not identified. And your lordship say page number 32. That is also the statement of Purna Chandra Das. He also stated that one Chandradhosh Barik, who is also implicated in this, who is identified him as Indra Deori. Not I have identified. I have only submitted the documents with good faith, man. I have not identified that he is Indra Deori, my lord. Nowhere it is stated that I have identified.
See. He is on bail? No.
No, he's not. He has to appear before a date has been fixed before sub-register, and since investigation is complete, charge is submitted, he will appear.
41A notice was given.
41A notice given.
Already want to pass. I'll modify.
And one thing, this is a judgment of Madras High Court, my lord. If your lordship see page, the paragraph number 6 is the relevant portions. Paragraph is the last portion.
You want me to write a judgment?
Sorry?
You want me to write a judgment? Then I'll write, no problem. But if you prejudice you.
For your lordship reference, I am showing that judgment. Paragraph 6.
All allegations are against you.
No, my lord, where, nowhere it is.
161 statement of one witness somewhere.
160 statement is before investigation, and it is always checking, my lord.
Which part?
It is not a substantive piece of.
Which paragraph you want to?
6 paragraph 6 last para, my lord. Paragraph para 6 last para.
Read it.
My lord, I have only one copy of, but I went through that. And paragraph 1 also, my lord.
This will not help you, madam.
Well, its lawyers is not responsible to the sins committed by the person client. I have never identified that he is Indra Deheri.
You read the FIR, you read the charge sheet, you read all the possible documents, everywhere your name comes. You are the principal
only
accused.
That statement of Prasant.
You are the principal accused. It can't be passed like that.
Is, well, lordship, I'm not praying that the proceedings should be closed. I'm just let the complainant to be appeared, my lord. Or let's be given one more chance only.
No.
My lord, where?
Merely because you are a lawyer doesn't mean that you see
the
allegations are just read the allegation for her satisfaction.
Only Prashant Kumar said that I have been that he stated.
Soros Kumar Barik's name has been taken by each and everyone. You are the lawyer, you have manipulated everything.
He stated that I have submitted the documents, my lord. But he never stated that I have identified that aggrieved person, my lord.
Lord, apart from the statement of Tahsildar Miller, another statement of Revati Raman alias Pintu Sahu Miller. ମୁଁ 19 ଆପଣ ଜଏନ୍ ହେଇକି ଯେ ମୁଁ ତହସିଲ ଅଫିସରେ କମ୍ପ୍ୟୁଟର ଦୋକାନ କରିଛି ମୋ ପାଖକୁ ଲୋକମାନେ କାଗଜପତ୍ର ଜେରକ୍ସ ଏବଂ ପ୍ରିଣ୍ଟିଂ କରିବା ପାଇଁ ଆସନ୍ତି ଗତ ତା 15/10/20 ତାରିଖ ସନ୍ଧ୍ୟା ସମୟରେ ଓକିଲ ସରୋଜ ବାରିକ ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ନୂଆ ଗାଁର ପ୍ରମୋଦ ସାହୁ ଆଦି ଆସି इंद्र देहुरी नाम रे एक affidavit प्रस्तुत कर प्रिंट कराइथिले yes particular
Well-
another person also not particular name
I know, I have seen.
My lord, he stated that
Unnecessary,
I have
if you
submitted.
insist me, then I'll have to write something.
My humble submission is, she only stated that I have submitted the documents but I have never identified that in person, that who was impersonate, that aggrieved person.
See that you have been taking that man to this place, that place. He was along with you.
Yes.
No,
He was along with you throughout.
my lord, he might have known to the Indradur, but I have never known Indradur.
You know everything. You have been taking that man
Where it is-
everywhere.
where-
Attestation,
No, I just-
photocopy, then preparation of typing, and everywhere you have taken that.
I just only.
And they have collected evidence from everywhere. And you are the lawyer. You are taking that man.
I may
Saying
be,
in-
I
in the-
might have present throughout all this, but I have never identified that person. It is Chandra Dhosbari.
If 6% have identified, one of them has not identified, seventh one.
Where it is written.
I will pass it.
No, I'm not praying for crossing it. My lord, I just was sick. My humble submission is let the complainant be appear.
You better withdraw it, persuade the complaint. If the complaint is agreed to settle, we come and file it.
It's a notice has been
Why should
served.
I be party to this?
Your lordship permitted me to make a complaint as a your lordship then I have
So, madam, unnecessary, don't bring create
One-
problem for your client.
only one more opportunity.
Liberty to file a fresh one.
My lordship, only one more opportunity, only one shot that is given.
No.
It will-
Your lawyer, the lawyers will start doing all these kind of things. I will not, I will not order. Okay,
That is correct. We are not opposing for time, my lord. What happens, my lord? This lady, after this man was, my lord, terminated from job pursuant to this conviction order, my lord. This lady is facing lots of difficulties because he has got two
Then
minor
why not
children.
putting it in the weekly,
My lord,
Taking it in the-
what I pray, your lordship may fix up a particular time after 2, my lord, at 2 PM, so that it can be
2
disposed.
PM things
On
are
a particular,
getting-
any
Rest
date,
of the entire list, my lord.
date may
Date,
be.
my lord, yes, date may be.
1 hour for a good day, which day? 23rd.
I'm present for Bhoranath Rout, subitem 2. Okay.
134.
Same, my lord. Mr. Marana will be appearing in this one. Mr. Marana will be appearing in this
Marana.
one. Yes.
134. Yes, next.
138.
38. This is weekly.
147.
132. 130 picture. Last one. Opposite party to notice self. Sir.
140.
In item 140, but twice words.
Respond number
notice sent to
service.
pin number 2. Last occasion, State Council has requested.
No,
to stop-
IIC Manchester Police Station.
To IIC looks. ଯାଇଛି।
Service.
150 କାହାର ତମ ପାଖରେ ଅଛି ଦେଖୁନ ଆସିଛି ନା ନାଇଁ ଆରେ ନୋଟିସ ଟା ଯାଇଥିଲୁ ଥ୍ରୁ ଆଇଆଇସି ସର୍ଭର ପାଇଁ ଇନଫର୍ମାଣ୍ଟ ଉପରେ ଯାଇଛି ନା ନାଇଁ
Let's check it up. Last order was to serve opposite party number 2 through IIC.
Instruction on 9924 million. IIC notice of
What is he writing? Submission of information. Service. He doesn't say anything about service. No, this last order, you just see the last order. Order dated 23/8/2024. IIT Manchester Station is directed to serve notice on opposite party number 2, indicating that the matter should be taken up on 12th of September 2024.
Teacher Lordship. Lordship, my item is 138, which is skipped.
Somebody mentioned in the next.
No, Lordship, I was there in the court.
This adjourned, senior counsel mentioned.
No, Lordship. I was physically present before your Lordship. Till launch. Somebody has mentioned for 135, 137 and 139.
Okay, what is this matter, let us? Service report 130. 138.
138 plus.
You're talking about 130.
138 service.
Huh? 132 कौन बोल रहा है? अच्छा, yes, service is complete.
Service complete.
Service complete. Yes, what do you say? Service is complete. Nobody appears for opposite party number 2.
Yes, Lordship. Lordship, I must recapitulate. I am the director of one nursing college at Jharsuguda. And we are imparting nursing education at there. And the complainant, the victim, the informant is the mother of the victim.
Yes.
She lost the case, present case. Lordship, kindly have a last time Lordship has gone through the details of the FIR. But here, the 161 statement,
yes,
that is in the page number 34 and 35.
Yes,
that is quite inconsistent. That's it, may be allowed to read.
That is one of the ground, major ground you have.
Yes, Lordship. Nowhere any
one statement of witnesses are inconsistent, therefore I will quash it.
No, Lordship, but it is not made out against me.
You say that the consistency are inconsistent. These are not evidences. I am not deciding the case finally. 161 statement is neither here nor there. I can't see whether it consistent, corroborates or not. The prima facie case is made out. What to do?
Statement.
No, Lordship.
Guys, statement of the victim, sir.
I can't analyze 161 statement at this stage.
Lordship. Well, both the statements of the victim and the informant, that doesn't disclose any sort of allegation against me. Also, Lordship, another one thing is that two independent witnesses, the witnesses, they are
you come to page 32 and read what is the charge sheet against you.
That's it.
Page 32. You are Sudhir Ranjan Nanda. 32.
Yes.
Come to page 32.
Yes, that's it.
Yes.
That on 1st February 2021, informant alleging that while her daughter Siddhi Gayatri, that is the victim, was undergoing nursing training at GNM, Behramal, Jharsuguda for the session so and so, she was harassed unnecessarily by college administration. On 31st January 2021, at about 4:30 p.m., third year students, she was a first year student.
Yes.
Third year students, Dilleswari Bag, she is also accused in this case, and Rasmita Maji abused her daughter in obscene languages. On 1st February 2021 morning, when she came to know about the same from her daughter over phone, she apprised to Director Sudhir Ranjan Nanda, the present accused, but he didn't take it seriously and asked her to meet him at college. On 1st February 2021 morning, when she, along with her husband, came from Biramitrapur and wanted to meet their daughter, Director Nanda told them that she appearing examination, which would be over at 5 or 6 p.m. and asked her to go back. In the meantime, her daughter, the victim, suddenly came weeping and told them that she was forcibly confined in a room by Dilleswari Bag and Rasmita Maji, as per the direction of the Director Sudhir Ranjan Nanda. She was not even allowed to appear the examination. When the daughter protested, they threatened her to kill. They threatened her to kill means the Dilleswari Bag and Rasmita Maji, though they have illegally confined her. They threatened her to kill. She inquired about the matter in detail from the daughter and there was danger to the life of her daughter due to regular threatening by Director Sudhir Ranjan Nanda, she lodged the report at Jharsuguda PS for the necessary action.
Is it not enough for the purpose of?
Lordship, may I submit, Lordship? But Lordship, kindly have a glance. The statement of
Yes.
one Lina Sahu in the page number 38.
Yes.
मोर ना लीना साहू मु जीएनएम ट्रेनिंग कॉलेज बेरामल झारसुगुड़ा द्वितीय वर्ष छात्री अटे आम सह सिद्धिक द प्रेजेंट विक्टिम ट्रेनिंग कोर्स करंती ता 30/1/2002 दिन आमर प्रैक्टिकल परीक्षा को विक्टिम सिद्धिक बेरा महिला अप्रोन पिंधि आसीथिबारु एक्सटर्नल मैडम रिमार्क कले आमे ट्रेनिंग कॉलेज सम्मान और प्रसंग होइथिबारु सही दिन आम ट्रेनिंग कॉलेज तृतीय वर्ष छात्री दिलेश्वरी बाग और रश्मिता माझी मिसी गायत्री बेहरा को गाली गुलज कले सिद्धि गायत्री बेहरा फोन ने बापा मां को जणाइबारु सेमाने आम ट्रेनिंग कॉलेज को आसी ताको झियो को देखा करिया पे चाहिबारु सेते बेले एट दैट पॉइंट ऑफ टाइम पेडियाट्रिक प्रैक्टिकल चालू थिला प्रैक्टिकल एग्जाम चालू थिला डायरेक्टर
सुधीर रंजन नंद मना करले
यस सर
रे थिबा हॉस्टल रूम रे परीक्षा सरीवा जाए बंद करी
I am the director of the institution.
read third floor रे थिबा हम हॉस्टल रूम रे
परीक्षा सरीवा जाए बंद करी रखिबा पे कहिबारु
you are with these two people that Dileshwar and ye that's the allegation.
Yes sir, that's the allegation of informant.
That's enough.
How that plus it when
the complaint of the parents.
Yes let's say
and the evidence which you read out all
yes,
are completely consistent, there is no doubt about it.
No let's say
then what else you need?
But let's say
how can I quash you? Tell me what are the grounds? You don't have any ground.
Charge sheet filed at 1/5/21 million. Trial might have been bigger than.
There is nothing to quash.
But SC/ST case doesn't arise.
That the trial court will see.
The stringent act for which already I am being incarcerated for more than 9 days without any allegation.
Yes. Yes.
सुधीर रंजन मते खराब भाषा रे गाड़ी देबा सह ताको आदेश क्रमे
हाड़ी बोली कहते just see the allegations.
Allegation मु कहिछि बोले allegation नाही लर्सी
yes. Anything else?
Let's see. If I read the 161 statement of informant, सेठी कहउचंती जे 1/2/2021 सकाळे पेज नंबर 35
yes
1/2/2021 सकाळे मो झियो मते पुणी फोन करी संगे संगे आसीबा को कहिबारु मु ओ मो स्वामी वीरमित्रपुर आसी झियो को देखा करिया पई चाहिबारु डायरेक्टर सुधीरानंद से ऊपर महला रे परीक्षा देउची संध्या 5टा कि 6टा रे सरीबो तापरे आसो तम झियो को देखा करियो बोली कहिले ठीक एही समय रे दिन प्राय 2टा हेबो मो झियो कांदी कांदी आसी मु ओ मोर स्वामी जीएनएम सेंटर रे थिबा समय रे मो पाखरे पहुंची गला ओ मो झियो कहिला डायरेक्टर सुधीर रंजन नंदन को आदेश क्रमे दिलेश्वरी बाग और रश्मिता माझी ताकू जबरदस्त गोटे कोठर रे बंद कर रखी देले तो परीक्षा देबा पई देले नै रसी परीक्षा तो स्टार्ट हला 2टा रे परीक्षा
प्रतिरोध करिवारु से दुई जो डायरेक्टर खराब भाषा गाली गुलज करी जीवन रे मारी देबा पई धमक देली
यस सर बट लसी काइंडली हैव अ ग्लांस ऑन द एफआईआर रो तो सेगुडा किछि कंप्लेंट नै Let's say FIR in the page number 12.
Same thing in the FIR now.
I know.
More Jia, Siddhi, Gayatri, Kandi,
Everywhere same thing. All the witnesses are.
The sequence is same, but there is no allegation that mu gali deichi boli.
At your instances, all these things have. That's the allegation, and that is the statement of all the witnesses.
Let's see.
I can't, sir. I can't find out the contradiction in a 161 statement of witnesses and quasi. Those things will be used in the trial. You raise all the point.
Yes. Let the matter come after 7 days. I can produce. I was
no. After arguing for such a long time, what is?
No. Let's see. I have got some.
Either you withdraw, I'll have to write an order.
Let's see. Let me produce.
No question. You wasted 20 minutes and there is nothing.
Prior to this,
even now you tell me if you have anything, you show me.
Let's see. This is with me. I am at Bhubaneswar right now. I was in the court.
I can hear you very perfectly. There is no doubt about it.
Prior to this, all the students, this incidents before first.
And you read out the evidence of another student, page 36.
Yes, sir.
All of them said the same thing.
No, sir.
Rather, they have added something. You have asked the girl to be put in a room in the hostel without allowing her to go to examination.
No, the issue started due to the remark of the external. That is the question of the integrity of the institution. All the students are supposed to get mark from the external examiner. That is why they were worried. That is the conflict between the victim and those students. I am not at all a party to it. See, ता पूर्वर मध्य विभिन्न समय रे एमती सब डिस्टर्बेंस करछि बोली ता नारे सबु जाक हॉस्टल लो स्टूडेंट जे कलेक्टर को भी कंप्लेंट या पूर्वर they have lodged complaint against this student, this victim.
Yes. And if you want to give a written note also, you can give judgment reserved.
Written note along with all these papers I can submit.
All the papers are there already. All 161 statements are there.
No, 160. Apart from that, these corroborating documents which I can adduce to this honorable court.
You can't do that if it is not form part of the charge sheet. I can't go into all these things. Those things will be your defense. You can't bring 1,000 documents and ask me to read those documents if that is not form part of the charge sheet. And the charge sheet, whatever there in the charge sheet, you have read it out.
Yes, sir.
All the witnesses are making allegation against you. All the students.
All the 2 students have, but that is not directly that I am the accused. That doesn't show.
Yes. See, Lina Sahu is 20 years. It's page 38. Just read Lina Sahu, page 38.
That is both have delivered.
Read out last 5-6 lines. Read it out. Read out. Read it out.
Training college
1 minute. Read out. तारीखो मझिरे तारीखो 1-2-2021
तापर 1-2 तापर ट्रेनिंग कॉलेज को आसी ताको जो सीधी गायत्री बेरा को देखा करिया चाहिबारु सेतोले
पेडियाट्रिक
प्रैक्टिकल परीक्षा चलथिबो डायरेक्टर
1 minute चलथिबारु तापर डायरेक्टर
सुधीर रंजन शर्मा मना कर
that is you सुधीर रंजन yes मना कलारु
हॉस्टल रूम रे परीक्षा सरे जे बंद कर रखिया पे कहिबारु दिलेश्वरी बाग रसरन मिसी गायत्री बेरा हॉस्टल रूम रे जोर जबरदस्ती रखिले किंतु किछि समय परे सीधी गायत्री बेरा हॉस्टल रूम आसी अभियोग बासी तार बापा को भेटी डायरेक्टर सुजन को विरुद्ध रे अभियोग करले.
What else you need?
Yes, sir. But at that time,
why should the student will tell against you? Yes. Next.
141. That's it. I will submit the written note of argument.
Yes, you do it. Please give it. Yes.
Deeply would like.
Yes.
141.
Yes.
Here, my lord, page 24,
Service,
answer
service.
3, my lord.
Service. Respondent note.
Challenging cognizance dated 69/22.
Service and respondent note 2. Huh? It is expired. Appearing from 141, no item?
141.
Is appearing soon.
Somebody is appealing with the petitioner or
And Mr. Sarath Behra is appearing soon. Mr. Behra, are you appearing?
Yes, Lordship. I am in person as R2, Lordship.
Okay.
In item number 141, Lordship.
Okay, in person.
Lordship,
What do you
petitioner has
want to
not
say?
served the complete document.
You don't have paper book.
I don't have the paper books which has annexed by the petitioner. They have only served the petition copy, not the annexed document, sir.
Despite non-appeals for the petitioner, Mr. Sarath Behra appears in person. Appears in person being opposite party number 2 and submits that he doesn't have the copy of the petition. The honorable for the petition is there to serve the entire set of the papers. Matter. 142. I am for the opposite party. Yes. He is challenging the Miller's 205 petition, rejecting the 205 petition. In the complaint petition, Miller's your lordship. 138. 138. Yes. And NBW issued, they have not appeared. Thereafter, NBW issued, not appeared, and filed 205 petition without prayer for the recall of the NBW. Only personal. Your lordship see that petition Miller page 18. Page 8, huh? Page 18. Show me the impugned order. Impugned order Miller's at page Miller's 27. That is the operative part. It is established that legal. It is established the legal position that personal attendance of the accused persons can be dispensed with under 205 CRPC in respect of the furtherness in women, old and sick persons, factory workers and labor workers, busy public officer, business and yes, infirm people. What about where is the NBW order? Plus, I am for the opposite party. NBW order, where is that? NBW, he has mentioned that. Where is that? Order of NBW. Dated. BW Miller's previous. BW is there, I have seen it. BW has been issued, same as in executive. You say NBW, where is that? With the direction of the accused before the court and the same again. That is, your lordship see that NBW. Miller's order dated Miller's 27/12/21. It is page Miller's not mentioned in the page, I think page 23. 20? 23. 23. Order dated 27/12/21. Case record is put up today on the strength of the advance petition. Advocate for the complainant filed a petition saying for NBW against the accused persons. Put up on such and such date. Thereafter, he might have appeared. Not appeared. No, see, thereafter, bailable warrant issued. Bailable warrant is issued on 23/2/21. Just above the order. Okay, okay. BW was issued, thereafter NBW, and filed a petition without recalling of the NBW 205 petition.
Petition para 5 million. They have mentioned not CBC TD by exchange one post issued NBW.
I have seen that order.
Yeah, they admitted.
And in para 5, he has stated that due to the unavoidable circumstances and the summon not properly served in the present petitioner, he could not able to
No, no, what I am thinking is just see, then come to impugn order, 12/3/2024. If the NBW was issued earlier, why subsequently bailable warrant is issued now?
Bailable warrant on 23/2.
No, no, you just see 24. 12/3/2024 order at page 27.
Similarly, further perusal of the record, it is found that on previous date, BW has been issued and same has been executed before the executive magistrate PVSR with representative office appear before the on 16/1/24. Here is a case order dated 23/2/21 shows that BW has issued.
Right on. Non-APS for the petitioner. Petitioner is assailing the order dated 12/3/2024, whereby his application under section 205 CRPC has been rejected by the trial court on the rejected by the trial court. This is a case arising out of a complaint under complaint under section 138. Also appear for opposite NIA. Perusal of the proceeding sheet indicate that against the petitioner, despite the summons issued to the petitioner did not appear in the court. Therefore, on 23/2/2021, bailable warrants were issued against the petitioner. Thereafter, also the petitioner did not appear. Therefore, on 30th March 2022, on 27/12/2022, NBW was issued against the petitioner for 30th March 2022. On that day also, the petitioner did not appear. Again, the NBW order was repeated. Instead of appearing before the court, despite the NBW order, the petitioner appears to have moved an application under section 105 CRPC. The trial court by the impugn order has rejected this. Hence, he has appealed this court. I am not going to interfere in this matter, as there is no legal infirmity in the matter. However, a petitioner is directed to appear before the court below on or before 15th of September 2024, October 15th October 2024, and seek remedy available to him under law. Under law. Till then, the execution of NBW shall be kept in abeyance. Yes.
143.
My lord, as far as this case is concerned, I filed this petition to pass the proceedings, specifically section 6 of OPID Act, basing on the order that has been settled principle that has been settled in Rasmita Patra versus State, and that has been previously also adopted in my case also. To bring your kind attention, I have filed this written argument also. That has been. I'd like to.
OPID, you are.
Again. So, as a previous, I have also filed a written argument last time. I would like to draw your lordship's kind attention. My company is SN Creation Private Limited. And as far as me is concerned, in 12/6/2014, and EOWPS case number. Again?
It's not. He doesn't have the papers. He doesn't have papers and all. He is not ready. Next week. Yes, Mr. Ragada, have you got any information?
No,
No. Next week.
They have giving that perfume within 14.
Huh?
They are sending melody.
Sending.
Within 14.
But still, my lord, after a judicial order to get the file hasn't come till now. It's a judicial order, my lord.
No, he'll get it. Huh? Let the report come. Report, yes.
But our information is that it's already there.
Already?
The report is already there.
Let us see. Yes.
Date.
No,
next
date.
week?
144.
Yes.
144.
144, may I please, Your Lordship. Sir, in the previous date, notice was issued in both the cases. My lord will remember that in this case, I had submitted that we are the victim's family. We are for the wife's family. We had lodged the FIR first at Annexer 3, Simulia PS case number.
What happened, service?
Sir, notice. Sir, after that, the mother-in-law of the victim girl, who is my family, we are the family of the victim girl. We lodged the FIR first, sir. After that, they lodged an FIR against us, in the same police station, where the police station denied to lodge that FIR because it's a cross FIR, due to which they lodged a 1CC case, and this FIR was lodged. And today I have challenged this cognizance order, my lord. It's a totally family dispute between the.
So I should notice, because once they come, I can send it to mediation or something.
Sir, I also humbly pray that if they would have come to the court in this case, I would have also prayed that if they can, because it is a family case,
Yes.
if any divorce case or any,
Let's see the position.
sir, if any compromise can be initiated by the informant.
Huh?
Sir, on other grounds, I have made various researches, if my lord hears the matter.
Then next week, let it come next week.
Sir, I humbly pray that my dates are coming every time. 27th is my next date of year. This is a family dispute. Hence, I humbly pray for consideration of my IA in both the cases.
No application. I'll just see.
My lord?
SI service, no one APS for opposite party number 2. Then counsel for the petition submits that the trial is proceeding in this matter, and the dispute is arising out of a family and this court, from this court. I think may move the appropriate application in the court below for seeking an adjournment, owing to the fact that the matter is subject before this court. Yes.
My lord.
Obliged.
145.
Yes.
Legal lodgement. Last occasion, I have served one extra copy to issue notice to the copy number 2 through
service through IAC.
IAC.
Then, third.
So that
instruction we have received, but we have sent the copy to the concerned ISM. Next week, I think we can take the confirmation.
Simply adjourn karo next week.
Only adjourn, yes.
Yes.
146.
Yes. Nobody there. Yes.
147, my lord, tomorrow at 4 p.m.
Your Lordship, the similar matter which has been heard, Jaswant Singh versus Union of India, let that order come and that will fix this case.
That is separation already. My lord,
And we have already filed the counter in
Let it come tomorrow, my lord.
Let it be there. We'll see. Yes. Yes.
154.
154.
54.
54.
There's nothing, my lords, in the first part. The entire charge sheet, if your lordship will see, there is no case against.
154. Revision. Yes.
So we had come up against an order refusing to discharge. When charge was filed, it was amended and the.
Who is appearing? Vigilance?
Mr.
You are appearing 154.
Yes.
Ready?
If we confide.
Yes, I am confining to that Vinod Bihari.
Yes.
584 of 2020.
Yes.
My lords may look at the impugned order dated 18/10/2022.
Vinod Bihari, yeah? Yes.
35.
18/10/2022, page 35.
Yes. Yes.
Your lordship may see what he writes in the third paragraph. It has been submitted by learned counsel on behalf of accused person so and so, that they, being subordinates to the accused collector, namely Debraj, have been compelled to sign on the resolution. And further, whatever overt alleged to have been done were monitored by the accused collector, and these accused had no independent active role, and as such are no way involved in the alleged offence under 13.2 read with 13.1d, PC Act read with 409, 465, 467, 471 by 120 IPC, and therefore they may be discharged. Then next page, my lords may see the third paragraph. Per contra, learned special PP, while raising objection, inter alia submitted that there are sufficient materials to show that accused have joined hands and were involved in corrupt practices in the examination and recruitment process conducted for RI, ARI, and Amin. And there are sufficient materials on record to show that these accused have committed the aforesaid offences. As such, their applications be rejected. The conclusion, my lords may see, peruse the case record, found that charge sheet has been placed against the above accused and others under section such and such. FIR, charge sheet, statement of witnesses recorded under 161 and other materials, including documents, filed would go to show that accused collector, namely Debraj Mishra, and other accused, namely Anita Panda, Bibi Das, L. Mundari, Aran Suna, and B. Maharana, and others, conducted recruitment examination for some posts of RI, ARI, and Amins. In this process, they adopted corrupt practices, further manipulated the forged marks and documents, thereby facilitated undeserved candidates for the post as aforesaid. Materials available on record prima facie reveals sufficient grounds regarding commission of the aforesaid offences. Grounds for discharge shown by the accused appear to be their defence plea, which can only be answered and settled in a regular trial after taking evidence and not at the very outset of hearing, particularly stage of framing of charge. Now he says he has perused all these documents. I'll only ask your lordship to kindly look at the charge sheet. The charge sheet is the next item in the brief, my lords. I'll just ask your lordship to kindly look at the last part of the charge sheet. That is the facts in brief. It begins at page 117.
117.
My lords.
Yes.
117.
117. 115 ରୁ ଆରମ୍ଭ ହେଇଛି. Your lordship may see from 115.
Yes.
The last paragraph, my lords. Allegation in brief is that as per direction of Government and Revenue and Disaster Management Department, letter number 112/2011, the then collector Bolangir issued advertisements on 17/12/2011 for filling up of 13 posts in the rank of RI, 17 ARI, and 20 in the rank of Amin. Last date of filing application was 21/2012. Thereafter, collector issued corrigendum about enhancement of some more posts, but last date of receipt of application previously fixed were unchanged. In response to the advertisement, 744 applications were made for the post of RI and 2076 for the post of ARI Amin, out of which 134 applications in the rank of RI and 353 applications of ARI Amins were rejected during verification. Then your lordship may omit that. Your lordship may go to the next page. Finally, 369 candidates for RI and 1107 candidates for ARI Amins appeared in the written examination during incumbency of Sri Devraj Mishra IAS, then Collector Bolangir. Sri Mishra has shown to have formed a recruitment committee in which 4 OS officers and 1 OWS officer were the members. He himself was the chairman. After completion of written examination on 9/6/13, answer sheets in sealed conditions were in the custody of Sri Mishra IAS, collector. On 15/6/13, the answer sheets were evaluated, during which it was seen that the answer papers, although received by the collector in sealed
You are one of the members of the committee.
Yes.
Yes.
Were found open and have been manipulated. In spite of that, as per order of Sri Mishra, marks were awarded and the manipulated answer sheets, some undeserved ineligible candidates were appointed to the post. Now, my lords may see at the last paragraph of that page.
What do you say? You say that it is in his custody, he might have done it.
No. Their own records show, my lords, only I am placing 3 or 4 paragraphs.
Yes.
The last paragraph, your lordship may see of 106 in the first line. The present accused Debraj joined as Collector Bolangir on 3/8/12. As per his order passed in file such and such, a selection committee was formed who conducted physical test of the candidates from 11/12/12 to 15/12/12. We were not part of this committee.
Yes.
Then, my lords may see the 3rd paragraph in the next page, 117. In the meantime, government decided to go for high-tech aerial survey of the entire Bolangir district from the month of June 13, and it was instructed to fill up all vacancies for the post of RI Amin. Then, my lords may see what he says. As per order number 967 ESTT dated 9/5/13 of Sri Mishra Collector Bolangir, Miss Anita Panda, Deputy Collector, brought the question papers and model answer sheets in sealed cover from BSc Odisha Cuttack on 20/5/2013. But as per order dated 20/5/13 of Sri Collector, Miss Panda only deposited the sealed question papers in the treasury on 21/5/13 and not the model answer sheet packet, which remained with Sri Mishra Collector. So the answer sheet packet remained with the collector. And then it is said, this is an important aspect which emits evil intention of the accused collector to maintain transparency and to make recruitment corruption free. The sealed model answer sheet packet should have been deposited with the question papers in the treasury, and it would have been brought in the morning of evaluation on 15/6/13. Then, my lords may see, further on 4/6/13, Miss Panda endorsed the proposal of the dealing assistant for opening of treasury strong room on 9/6/13 to bring the question papers for written examination and further keep the used answer sheets back in the strong room in the evening after the examination is over. We may omit, my lords, the next 3 lines. Then he says, the collector has approved the entire note sheet. Hence, he should have signed both the draft orders. But the draft meant to deposit the used answer sheets came back unsigned. This proves the intention of the collector that he wanted to keep the answer sheets and the scoring sheets with him. The records show that again a recruitment committee was constituted by order dated 4/2/13 under the signature of Sri Devraj Mishra, where the collector was the chairman, Miss Anita Panda, deputy collector, Binod Bihari Das, that is the present petitioner. Then the names of the other co-accused milords are the members.
That was formed on 4/2/2020.
Yes, milord. And this committee was never formed, it was only formed on paper. That is apparent if your lordship will see page 108 in the same paragraph. 5 lines. But none of the above 5 members agreed to have received memo dated 4/2/2013. Even they denied having any knowledge about formation of such committee till 21/6/13 evening. Concerned files also reveal that the order has been passed directly by the collector. No note sheet has been generated by the dealing assistant, nor routed through head clerk and the establishment officer. Further, the seized letter issue register of establishment section revealed that issue number 321 and 322 have been inserted at page 46 later on through manipulation. The seized peon book proves that no letter has been served upon the members. This is important. From the above, it is clearly proved that order number 321 has been manufactured later to throw responsibility on others. Then, my lords may see,
I think
this is sufficient.
how
In fact, Lordship,
the
permit-
committee formed?
Lordship,
They were formed part of the committee.
my Lord, I understand your Lordship, the fag end of the day, my Lords. Lordship also, we all are really exhausted, my Lord. But I will take only 7 minutes, my Lordship. Lords. Lordship, to reiterate the 3
The
lines.
formation of committee itself is a fault.
My Lord,
Which they supposed to be the they are supposed to, he is supposed to be a member of that.
now, my Lords, with regard to the statements made by my Lord friend Mr. Panda, my Lords, I'll just repeat 3 lines only. My Lord, everything started in 2011, December 2011, advertisement issued pursuant to government decision, my Lords, and for the advertisement issued by the collector Balangir, who is the main accused in this case out of the 45 accused persons. My Lords, the advertisement is.
Collector and that Anita, what is that?
My Lords, in fact, collector was the chairman of the committee. He formulated, my Lords. Anita, my Lordship, ought not name, but he's the convener of the committee, my Lords. The petitioner is one of the member of the committee. My Lords, everything started in December.
No, your investigation says that committee is particularly created only to throw the responsibility
on others,
on these people, and that committee was never formed. That is what you are finding.
Exactly.
It was never formed. On 4/2/2013.
If Lordship permits me to place, I can finish you 7 minutes, my Lords. My Lords, in 2011, the advertisement is issued. And for filling of 13 post of revenue inspector, 17 assistant revenue inspector, 20 amines, my Lords. And after shortlisting of application, in fact, 369 applicants for the post of RI appeared in the written, and 107 persons they found qualified to appear in the written examination, my Lord. Thereafter, a recruitment committee was formulated in February 2013, my Lords. But the collector, who was accused number 1, he became the chairman of that committee, and Anita Panda, deputy collector, was the convener. The petitioner is one of the member of that. The petitioner at that time was the BDO Balangir, my Lords. Now, my Lordship, turn to page 41 of Lordship. I will not take much time.
40?
Page 41 of your Lordship brief notes. That's a part of the material produced by the prosecution at the time of consideration of his discharge application.
Yes.
Page 41 notes.
Yes.
Lordship, got it, my Lords?
Yes, I got it.
My Lordship, I'm placing that second. I just play a few minutes that during the inquiry I further found that the required computer practical taste for the aforesaid applicants were held in 12/6/2013, 13/6/2013 in presence of Srimati so-and-so, and my Lord Sri B.V. Das, the petitioner, the BDO Balangir, my Lords, and so, remain in charge of the valuation of centers. On my inquiry, this is important, Lords. On my inquiry, is found no coding system was applied for valuation of the exams paper. I also found that some applicants secure 100 marks in arithmetic paper. What I want to give emphasis on the word arithmetic word, and for which I verified those papers found.
Saying this?
The informant.
This is my Lord's
part of the affair.
Part of the.
He's trying to find out fault with the examination system, which committee conducted by a committee.
But the entire thing, my Lords, revolves around this particular thing. My Lords, the applicant secured 100 marks in arithmetic paper. The word important in this case, in this particular page, is arithmetic paper. Some kind of manipulation is there, my Lords. People, some of the candidates got 100 out of 100, my Lords. Now, in the last line, last few lines in that second paragraph from the bottom, I found similar manipulation in some other papers. Now, what is the other paper? Your Lordship may turn to page 119 of your Lordship report. Within 2 minutes, I'll finish it. Yes. I understand your Lordship is exhausted. 119, my Lords.
119, okay.
I'll not place the entire thing, Lordship got it, notes?
Yes.
On 15/6/2013 at so and so and so and so, Lordship can come to the fourth line. The fourth line starts Sri Mishra.
OS officer.
See, collector, the collector directed the OS officer. Petitioner is one of them, Lords. And what they have been assigned to the duty. What is the duty? To evaluate the ODI paper only. And Lordship, come to the next line. When both the OS officer are evaluating the ODI paper, the answer sheet of arithmetic, general awareness, computer. The theory is applied to material staffs.
Ministerial.
My lord, these are the subjects, my lords, on the papers. What are that? Arithmetic, general awareness.
Was there any problem?
That's my lords. That's the same, lord. And my lords, and in the middle portion, there is a line, my lord. After about half an hour, the collector asks the OS officer to sign on those answers. The petitioner, before Lordship, lords, is admittedly a part of that committee, lords. In that committee, collector was the convener, and Miss Panda was the deputy collector, the convener. And he was assigned,
we refused to sign.
He was assigned with the one to evaluate the ODI paper. The entire allegations are pinned with three subjects. One is arithmetic, general awareness, computers.
ODI there was nothing. No.
And that's why I say this is a case which fall within the category of, from out the materials produced by prosecution, disclose suspicion, not the grave suspicion.
You are investigating a officer on he himself says that they were
all those manipulations.
Committee was only constituted by the collector.
Even accepting that is correct, my lord, without finding what is the role played by the petitioner. The role played by petitioner, the duties assigned to him is ODI paper only. All the allegations on three papers, arithmetic, the manipulation are found out, then the computer papers, and then
there is ODI paper, there is nothing. And after evaluation, allegation is the collector has kept it in his custody.
That's why
he should have given it to the treasury.
But they also protested in that particular process.
And when he got exposed, he formed a committee, and so that his responsibilities.
I also reiterated what my friend said, lords, that they also protested. Well, there is no coding system. But they were asked by the collector, the main accused, to put signature. So far, petitioner's role played in that case, my lord, is only to evaluate the ODI paper rule. My lord. No allegations regard that any kind of tamperings or manipulation with that ODI papers. It's confined to the three papers: arithmetics. Some students got unqualified persons, my lord, so they got 100 persons, my lord. Then the computers. Then the third subject is
general awareness.
General awareness.
They got this job also.
That's why, Lord, I say this case doesn't fall within the scope and ambit of the categories of grave suspicion. That's all. And I'm
written note.
We'll do that.
But the other cases, my lord, other cases appended to this case may taken off.
Yes, they may be separated.
After vacation.
This is only Binod.
584 of 2020.
What about the other? You have to see the role of all.
Yes,
that let it be done after the vacation.
The complicity department, I'll note a submission on all the same.
Interim orders to continue in the other two matters, connected matters. Interim orders to continue.
Your Lordship, on 11th, we had an argument, and today I'm submitting the written note of that.
Give it.
Similar, one written note given, similar to the second.
Yes, Mr. Raghunath.
I have telephoned them, my lord. They received my phone to 2:45 p.m. and they stated me that doctor will check up the petitioner and accordingly will send the report, my lord. But just 5 minutes before I have telephoned me, respond me, but he stated that wait some time I will be sending the report, my lord.
Now 4 o'clock I said 4 o'clock.
4 o'clock. After 4 o'clock, I want to engage, my lord.
I have a small request. But admittedly, some hospital has indicated very serious. Then, my lord, they took a second time an opinion from the capital hospital. Some also the police went. My lord, let it go to the AIMS. Let her be taken to the AIMS for examination. That's all I require. That's the fundamental right of mine.
Take her to
Yes. Take her to AIMS. That's the order.
She's a lawyer. She's a lawyer. You have to give treatment. I'm not saying anything. You give treatment at least.
Yes, and we are prepared to pay for it.
You give instruction that she will be taken to the AIMS hospital today, and tomorrow the matter is listed before the bench at 10:30. And along with report, I will, I shouldn't do it, but I'll do it because of the lawyer is involved. I'll speak to the honorable judge who is going to hear the matter. This is what I have instructed.
Report has come. Report has come.
Yes, tell me the report.
Report.
Read the report. Hmm?
Handwriting. It's not easily readable. What am I there? Read it. Read it.
It appears to be an ego issue
Absolutely, my lord.
between group.
No, my lord, it has now been transferred to crime branch. My lord, the seriousness of the matter is that she was assaulted brutally there. My lord, I'll demonstrate because, and she was first, when she came in, both the photographs, they have taken, the police. She is fine. Thereafter, she is brutally beaten up. Then the FIR is not even registered of the, when he was writing the FIR, that is also a photograph. What is it?
Get
Nice.
three printouts.
And in fact, my lord, law is settled that they have to have CCTV camera, my lord. They don't have in this. That's not there.
People are struggling to moving applications to preserve it.
Yes.
The idea is to have it.
Yes.
Why should people will move applications? Please preserve it.
Yes.
Directions are short.
Direct from Supreme Court, my lord.
Every
And they're not doing it.
This
They're not
may
doing
be
it. My lord, my own driver was beaten brutally by the Kanan Vihar police station. And we went to the, my lord, it's very sad state of affairs. Here, my lord, the Prime Minister, the Raksha Mantri has been talked to. The people have taken out. The man the entire ex-servicemen, my lord, have come forward to support that because she's a brigadier's daughter. And the army is supporting this gentleman who's been arrested, my lord.
She has been referred, my lord, referred.
Referred to?
My lord, no, exactly. Higher hospital. Higher hospital.
Higher hospital.
For,
To AIMS.
For further treatment.
To AIMS, my lord.
Three copies. Give it to both of them. Give it.
Second page.
Repeated assault injuries, my lord. On 15/9. She has been.
Police station, in the police station.
Yes.
Higher government.
Higher government.
Further,
Yes, AIMS is Government of India's hospital.
As needed. As per the complaint of the utility. Second page.
Second page.
Second paragraph.
Jail hospital.
Higher government hospital for further evaluation and treatment.
Higher
Government hospital.
Government hospital. AIMS is.
No, AIMS, not
AIMS. AIMS is the government hospital, man. Government of India. AIMS.
Who is the IO?
IO might have been transferred now to crime branch. The IO is, I mean. No, my lord, let it go to AIMS.
All right, no. Today you do it. AIMS, along with the AIMS report, list it tomorrow.
Yes.
AIMS doctor report has to be there tomorrow.
Yes.
And this is the report says that she was beaten up in the police station.
Yes.
The report itself says. What else you need?
But that is my referral level. The jail
They didn't
doctor
even, in fact, they have not even put, they have not registered this person's FIR also.
The report itself says, just see, you say that she was beaten up in the police station. Inside the police station.
Preliminary treatment, my lord, for some hospital. Preliminary treatment.
No, nothing less than AIMS. You get the AIMS report by tomorrow and by 10:30 you list it. 10:30. If Justice Mahapatra is not sitting, list it here. Okay, along with the report.
My lord, they are not even now also, they are not.
Make this report
with
part of the application which they have moved. Attach this report, and Ames report by tomorrow morning.
Since that we need some judicial order so that when they will taken to the hospital.
Why judicial order? The file is not there. Tomorrow there will be a serious judicial order. I tell you, if you don't do it, you just convey it. Convey to the concerned SP.
What happened, my lord? In fact, my lord, if they move
You say that you have an opinion. This report says that she needs treatment in the higher hospital. Which is the better higher hospital? Ames is the better higher. You agree to that extent? So send it to Ames. What is the big deal about it? Your opinion is she has to be referred to a higher officer, a higher hospital. And the Ames is the best higher officer, hospital. What else you need?
The police personnel, I will take it.
IO has to take, and I have to be present tomorrow in the court. Tell him to.
Basing on disciplinary, if your lordship pass an order, basing on.
No, I will not pass the order because the file is not there. I am just because he is a lawyer. I tell the IO to appear in VC tomorrow, along with the report. I'll convey this. This is orally I am saying, but I'll convey it to the concerned court.
One thing, my lord, since he has been referred to the government hospital, my lord, only the police can take jail authority will take him to take her to the hospital.
I don't know. Everything can be done. You know that. How it can be done, you know that. Who else knows better than you? You get it done. I don't know. Tomorrow, along with Ames report, and this report will be form part of the file, and it will be listed at 10:30. And tell the IO to appear through VC.
Unless until there is no such order.
You convey it. This is what I am saying. You convey it.
Instruction that you ask.
Convey it.
You are the officer
of the court. You are the officer of the court. It is happening in the open court.
Yes.
And everything is going on in the life. What else they need? And if there is judicial order, he will be rather in problem. It is only request that you please convey. And 10:30 the matter will be taken up along with all the reports. And IO to be present in the court through VC. No problem. Through VC. Whoever is there. I'll convey it. If it comes to me, it's well and good. If the coordinate bench is holding tomorrow, and I'll convey whatever has transpired today, I'll convey to him.
My lord, item 146. Yes. I could not able to attend due to net problem. Tomorrow it can be taken.
It will remain. We will see.
It's possible.
Yes. Let it be there. We'll see. Okay, tomorrow.